In view of the aforesaid facts and circumstances, this court is of the opinion that a case of interference is made out. Accordingly, the termination order dated 6/11/23 is interfered with. Consequently, respondent refinery is directed to allow the petitioner to complete the contractual liabilities in terms of the work order dated 29/3. It is also made clear that the respondent authority cannot restrain the petitioner from engaging its own man for discharge of the duties. Since the contract was for 2 years and because of the issue involved, the petitioner could not discharge the same. The petitioner would have the liberty to file application for allowing to discharge the functions for the full term, and in case such application is made, the same would be considered by the respondent refinery in accordance with law, and by passing a speaking order, petition stands allowed. Yes.
But I take to mention for listing, my lord, pending case, if pleadings is completed in this case, my lord. Matters pertains to my lord, cancellation of my fair price shop license.
Matter which year?
My lord, 2023. My lord, next week, any day.
Sorry.
Will come on admission, my lord.
23-24 matter not out of turn listing unless you make it a case of extreme urgency. Yes.
May I please, Lordship? With the concept of other side, I beg to mention for item number 24, Lordship. In this matter, we have received affidavit in opposition of resolution number 3, 4, and 5. When we prefer 4 weeks time for filing reply.
Your name?
Can I can? I am for petition.
24.
24, 27.
27. Okay. Who has filed the affidavit? Jorhat Municipal Board.
Lordship.
Okay. How much time do you require?
4 weeks time.
On the prayer of Sri N.I. Khan, learned counsel for the petitioner, matter is adjourned by 3 weeks to enable filing of rejoinder affidavit. Yes.
May I please, Lordship?
3 weeks solo, 4 weeks solo? 3 weeks. Okay.
May I please, Lordship? Lordship, in item number 43, I'm appearing for a petitioner, and I have received the instruction from the petitioner to withdraw the instant petition. Lordship, may kindly allow to withdraw this petition.
My lord,
43.
my lord, I'm appearing for the private respondent number 8 in that petition.
Yes.
My learned friend is informed me.
Okay. Your Lenso,
Yes, Lord.
Sri Lenso, learned counsel for the petitioner, submits that there are instructions not to press this petition. Full stop. Also heard State Sri G. Bokolia, learned state counsel, as well as Sri H. Buragohai, learned counsel for the respondent number
8, my lord.
8. Full stop para. Petition is accordingly dismissed as not pressed. Yes.
Much obliged.
Obliged, my lord. Much obliged.
Then, who is Miss H. Bora? Yes, not.
My lord, they are appearing for the rest of the remaining.
Okay, now we record their names.
Yes.
H. Bora, who is H. Bora?
My lord, councilman appearing for respondent
H. Bora, huh? R10. Okay.
number 9 and 10.
10, I think. 10. Yes.
But I beg to mention item number 13 of today's petition.
Yes.
Lordship, we have annexed the last annexure. We have annexed a rule, Lordship, that is not complete. And there is some discrepancy in the rule. Lordship, may kindly take it up on Monday and allow us to change the rule and incorporate the rule.
You have an extra copy with you. Place it before the court.
Sure.
Why do you require? Will you adjourn it? Okay. On the prayer made on behalf of the petitioner, matter is adjourned to be listed on Monday.
May I please, I beg to mention 2 IS formal withdrawal on Monday.
Withdrawal.
Yes.
Okay.
With the consent of other side, I beg to mention item number 52 of the
Yes.
case stated. We
52.
will file affidavit in opposition. 4 weeks time may be granted.
Yeah, for whom?
RDP
Okay.
respondent number 5.
On a prayer made on behalf of the respondent number 5, matter is adjourned by 4 weeks to enable filing of affidavit in opposition.
Wait, please, your lordship.
Yes,
Your lordship, I like to mention item number 44. May
Hmm.
the matter be not taken up by lordship as Andeka is appearing on behalf of the.
okay. 44 list before any other bench without me.
May I tell, Lord?
Yes,
Lordship, I am paying for list the matter, Lordship. The matter relates to Lordship NIT, Lordship. And the order was issued in favor
matter of
of
which year?
24, Lord.
24, NIT, what is the urgency?
Lordship, urgency, Lordship, order is passed in favor of the respondent, Lordship. And in fact, Lordship, first of all, the committee recommended the name of the petitioner. And in his place, the name of the name has been inserted, Lordship, the respondent, Lordship. So, Lordship, kindly, Lord.
What is the stage?
Say the admission.
What? So,
Ne-
okay,
next-
Friday, next Friday.
Friday.
Yes,
May it please your lordship. Lordship, I beg for listing of a petition. It's a pensionary matter.
pension not before this bench. Bench 3 matter. Okay, this is bench 4.
Please, your lordship, I beg to mention item number 28.
Yes,
Kindly the matter may be adjourned for the day.
28. Here for whom?
Ember,
Inform the, yes, Mr. Parashar, you are it, Mr. Parashar?
Yes. We have the consent.
Okay, we'll have it next after a week. On a prayer made on behalf of the petitioner, list after a week. Yes,
May it please, your lordship. I beg to mention item number 22 to this thing.
20,
2, my lord.
yes,
My lord, this matter is relating to my lord bench 3 matter.
bench 3,
Yes, ma'am.
yes, CGC, who is looking after this matter? 22. You are S. Upadhyay?
Yes.
Sri S. Upadhyay Learned Council for the petitioners submits that the subject matter is of civil bench 3. Para, registry to verify and list before the appropriate bench.
Deeply with that.
Yes,
May I please, lordship, I beg to mention the listing matter for withdrawal.
withdrawal, okay. Monday,
One,
I beg to mention item number 16, your lordship. This matter perhaps became infectious, so I have to take instruction, your lordship. My stay is also out of this. So matter may be adjourned for the day any day next week. your
item
lordship.
16.
16, your lordship.
16.
Sure.
You are there.
Sure.
Your names are not there. Is it 16 or some other matter?
Yeah,
What is the name of the case?
been to Purva, your lordship.
No, it's not there.
In the law, all this which was said, yeah, item number 16 is item 19, your lord. But in the process, yeah, we have been received by telegram, it is item 16.
Fine. Telegram about 19 to 16 recently.
Item 19, your lord.
2016 matter. What is
Sure.
the subject matter involved?
Lordship,
Let it
is-
reach. Let it reach. If it's become infractions, we'll come to know. What is
Lordship,
it?
Any day next week. your lordship,
Tenure of market or what?
Lordship, no,
What?
it is regarding unauthorized construction. Lordship.
If it will become infractions, you will close
Lordship, we
this.
take instruction, my senior is out of station for admission for his daughter at Bangalore. So he is also not with us, your lord. That is why, any day next week, your
Okay,
lord.
Wednesday next.
But it-
On a request made on behalf of the petitioner, a slight accommodation is granted, directing listing of this matter on Wednesday next. Date. Wednesday hole 11th of 11th.
Item 19, lord,
Yes.
19.
Item 19, Mintu Borwa.
Into.
Yes.
Obliged, lord.
Lordship, due consent from the other side, lordship. Lordship, I beg to mention item number 48. Kindly
Yes.
fix the matter after 1 week, lord.
48.
Yes, lord.
Yeah, for the petitioner,
Yes, Lord.
on a request made on behalf of the petitioner, matter is adjourned to be listed after a week.
My lord.
May I please, your lordship? I beg to mention for non-payment of supplier's bill.
Non-payment of matter of which year?
Matter, 22/11/23.
Matter of which year?
23.
23.
Yes.
When was it last listed?
Hmm?
When was it last listed?
Last posting date was 5/8/24.
What is the urgency? 580 was this. Sorry, next.
Maybe not on urgent matter, but may allowed to move today itself.
Motion.
Motion.
What is the urgency?
Lord, the AGM and election of a particular society without proceeding the procedure of law.
Okay, cooperation. Madam,
I will inform.
please cooperate.
My lord, I will inform and a copy will be supplied.
Okay.
Okay.
For six.
Develop.
Huh? Vice Chair. Who had mentioned item number 22? 22. S. Upadhyay. You know matter, so. No problem. Yes, where is Mr. S. Upadhyay? Yeah, 22 to Nilekiba. Call Mr. S. Upadhyay. Phone call.
I think 55 for withdrawal.
Yes, counsel for 55. Okay, all of this somebody. नाम to record करिए and I लिखित हुई दी issuance of learned counsel for the petitioner submits that by flux of time. No, submits that there is instructions to withdraw this petition, full stop. Also heard Sri G. Bokolia, Learned State Council. Industries, Mr. Kolita, and A. Kolita, Learned Standing Council. Industries and Commerce Department. Red petition is accordingly dismissed on withdrawal. Just tentatively making the order. Whoever comes will put the name. 55.
Item on top of the list.
May I please, your lordship? My lord, in fact, my lord, in our case, my lord, the director has filed their, my lord, affidavit in opposition. The director has supported our case, my lord. My lord will kindly have a look in the second page of affidavit in opposition. Para number 4, my lord, in the bottom, my lord.
Yes.
The second page of affidavit in opposition, my lord. The list which was forwarded by the district scrutiny committee, my lord, that has been, my lord, accepted, my lord, by the concerned director. And because of land dispute, my lord, which was filed falsely by one Hindi teacher, my lord. He said that, my lord, our school doesn't have, my lord,
We'll
sufficient-
consider this
Yes, my lord.
appropriate.
Can you dispose of this case?
When? Tuesday next?
Well-
Not on a motion day. We'll apply our
Well-
mind. Okay. Today, there are many matters. It may not be possible. Okay. The director of school
Elementary tuition.
elementary education has filed affidavit in opposition on 22/8/2024. Para, as on request, list for admission hearing on you are not a party.
No, my lord. Yes,
Then-
my lord. But our order has been passed on the basis of in 33, my lord. Order IA my lord 139, my lord. On the basis of the order passed in 139, my lord.
You're not correct. Come to page 38, second paragraph. 138,
My lord.
page 38, second paragraph.
My lord, second paragraph, but the order passed in 18, my lord. They did not consider the paragraph 6,
You
my lord.
challenge it. How it will be a contempt? What is a contempt? The order may be erroneous. You challenge it.
My lord, our order passed on the basis of the order passed
Sorry,
in
we are
one.
going to dismiss this then.
Let me will determine.
No, sorry.
My lord,
If you do not seek
My
the,
my lord, let
we
me
are
withdraw-
we are asking you from time to
My
time. You
my lord.
challenge it. You
Let
don't
me-
want to challenge.
my lord, without this,
Why do you waste the time of the court?
my lord,
Your time may not be precious. Our time is very precious.
my lord,
Have you seen the number of counsels behind you?
my lord.
For issuance of a notice, if we take 10 minutes in a contempt petition, what will happen to the other cases?
Sorry, my lord.
Are we reluctant to issue notice in a contempt petition? Never. It's almost a matter of right. You show us a violation. Sri R. Borua, learned. This case has been instituted. This contempt case has been instituted, alleging willful and deliberate disobedience of a judgment and order dated 23/2/2024, passed in WPC 1498 of 2022. It, however, transpires that on 18/6/2024, the Commissionerate of Food, Civil Supplies, Consumer Affairs, and Legal Metrology, Assam, has passed an order which has been stated to be in terms of the direction of this court dated 23/2/2024. Though the aforesaid order may be challenged in an appropriate manner, the aspect of there being willful and deliberate disobedience may not arise. Full stop. At this stage, Sri Borua, learned counsel for the petitioner, prays for a liberty to withdraw this writ petition and to file and to challenge the aforesaid order in an appropriate manner. Petition is accordingly dismissed on withdrawal with liberty as prayed for.
Keep your place.
May I please, Your
Yes.
Lordship, this is a contempt petition here, but their Lordship willful and deliberate violation of order 1802.
Where is the order
Operative part at page 12, Your Lordship,
regarding?
regarding payment of SKDC, Your Lord. In this order, Your Lordship, Honorable Court directed to the contemptor respondent, made the inquiry and thereafter, if found genuine, then they shall pay the compensation within a period of
Sri
3
S.I.
months.
Akand, learned counsel for the petitioner who has complained about so and so, deliberate and so and so. The representations filed after the order and the postal track record have also been annexed. Para issue notice returnable by 6 weeks. 6 weeks. Stamps by registered post AD within 2 working days. Yes.
So,
Yes.
Met to the lordship. This is an petition matter regarding subsidy matter. This is second round of litigation.
Yes.
Already the proceedings are complete. They have filed the affidavit. I have filed also my
Okay,
reply.
they have to be
You
issued.
haven't filed the affidavit, Lordship. Notice hasn't been issued this matter.
Notice has not been issued.
So, I
We'll
mean,
issue notice today.
Lordship,
We'll issue notice today.
notice and will, if required, will file affidavit.
Heard Ms. Ansaikia, learned counsel
Thank you, sir.
for the petitioner.
For this one. Thank you.
Para, this is the second round of litigation and the instant petition has been filed against an order dated 15/12/2023, whereby the representation of the petitioner filed pursuant to an earlier order of this court dated 16/8/2022 has been rejected. Para, let notice be issued. Returnable by 6 weeks. Union of India? Union
Union of
CGC. Mr. Miss Sri B. Chakraborty learned CGC accepts notice on behalf of respondent number 1. Mr. Kolita for 2 and 3. 2 and 3.
Two and three, yeah.
I think 6 also.
2 and 3 and 6.
Six.
Yeah, practice.
A Kolita, standing counsel, industries, commerce,
Yes.
2, 3 and 6.
Mr. Chakraborty is for 1.
1. And net fee, they have a counsel.
Mr. Bhatra can appear.
Batra.
R.K. Bhatra, Rajesh Bhatra.
Is he a standing counsel? Is he there in the court?
Yeah, I haven't seen it. Another person called Gitartha Das, he is also.
Gitartha Singh
Gitartha is also.
is not there.
He is not there.
Um,
Bhatra is there.
And mission director, National Mission for Food
Mr.
Processing,
He has to
State
appear.
Mission Director,
Mr.
National
Kolita
Mission
has
for
to
Food
appear.
Processing. State Council will appear or what?
State Council,
Mr. Bokolian?
not State Council, my lord, Industry Department.
Mission director is no longer there, Lordship, actually. That
Post has been
that
abolished.
post is abolished.
Somebody else, Salmoti was in charge. At
I'll
present,
appear,
he
Lordship,
is
I'll
not
appear.
there. He will
because-
appear.
2, 3, 5 ho loga di. 5, 6. Okay.
Five.
4 और लिखिबा.
extra, we make
Okay, extra copies within 2 working days. As regards the
Okay.
respondent number 4, comma, this court has been informed that there is a standing counsel. Full stop. Extra copy of the writ petition may be served upon him.
Lovely.
All right.
Item 5 and 6.
Lordship, on last occasion, Lordship, I was directed to take instruction regarding there is any arbitration clause or not.
Regarding any, what clause?
Arbitration clause.
Arbitration
Yes,
clause.
Lordship. Here arbitration, yes,
What is the dispute about?
matter participant non-payment of contractual bill matter. My lord, by simple price, let them verify, my lord. If I am eligible, my lord, in fact, my lord, complaint certificate, my lord, those are can come to 15, my lord.
Both are similar.
My lord, what
How-
different, my lord? Just 15, my lord, complaint certificate, my lord, and come to point 12, my lord. There, my lord, the work has been completed in that on 26/2021, my lord, and come to point 12, my lord. Up to the bill, up to date bill value, 2,99,48,700.
But this court has taken a view on 28/2/2024. How can we simply brush aside that view?
So, my lord,
See what is the expression, manner in which cases are being filed routinely for non-payment of contractual bills, keeping in view the fact alternative remedies that are available needs to be checked. Petitioner should inform the court as to whether there is any agreement regarding any arbitration clause. We cannot simply, otherwise if these observations were not there, you file for arbitration, matter ends there.
no, there is no dispute, my lord, between the parties. my
We
lord. Only,
cannot take a different view.
my lord,
Some view has been expressed.
my lord, what, my lord, probably, my lord, what a taken view, my lord, so that there is a dispute, my lord. In fact, my lord, there is no dispute, my lord. If there is
Dispute is non-payment of the bill.
my lord, in the parties to what there is
Then
no,
why have you come to the court if there is no dispute?
my lord, it is a admitted amount, my lord, and they have paid 16, my lord, it may also 16, my lord.
We cannot take a different view. 28/2/2024, a view has been expressed by the court. And thereafter, instructions have been obtained by Madam. Arbitration clause is there. You avail your remedy in arbitration. heard 3S Hoc learned counsel for the petitioner, who has approached this court for with the grievance of non-payment of contractual bills. Full stop. Para. This court, in its order dated 28/2/2024, had, however, observed that without availing the alternative remedy, matters of this nature are routinely filed in this court, and accordingly, directions were issued to obtain instructions on the availability of an arbitration clause. Full stop. Para. For ready reference, the aforesaid order is quoted, is expected herein below. 28/2/2024. Huh? Para. Miss R.B. Bora, Learned Standing Counsel, BTC, has obtained instructions and also placed the relevant tender documents as per which there exists an arbitration clause. Full stop. In view of the above and in terms of the earlier order passed by this court, the writ petition is closed by giving liberty to the petitioner to avail the remedy as envisaged under the contract between the parties. This court has, however, made it clear that closure of the writ petition is only on the technical grounds and not on the merits of the petitioner. বেলেগ কেছটো অকমান বেলেগ হ'ব এছ হক লিখিব প্ৰথমতে হাৰ্ড চি এছ হক হা দুইটা একে order to be same is the same order. Earlier order was the same date.
Yes, sir.
Okay.
Obligement.
Yes, sir.
My lord, the order challenge is by the authority under the Payment of Gratuity Act. My lord, the controlling authority has passed an order, my lord, directing to pay gratuity.
I think there's a standing council. Okay.
No, my lord.
No.
My lord, the
Yes.
now the impugn order is at, my lord, page 85, my lord.
85,
Lord, 90, my lord, page 90.
90. 90. Yes.
I'm sorry, my lord, it is 64. I'm sorry, my lord. Page 64,
64. Yes.
my lord. Here the, my lord, the controlling authority under the Payment of Gratuity Act, my lord, has taken the continuous service, my lord, as 10 years, 3 months and 16 days, my lord. As per the,
Why haven't you filed an appeal?
my lord, under the act, there is no provision, my lord. It has, the order passed by the controlling authority is final. So, my lord, it has to be under 226. My
Have
lord,
you
we
checked
take-
the law?
My lord,
Have you checked or making a
yes, I
submission
have
in
checked,
the
my
air?
lord. I have checked. Payment
Let
of
us also check.
Payment of Gratuity Act, my lord, 1972.
Read 7(7) and read Rule 18. Mr. Gupta, you should do the minimum homework. Don't make submissions like this. You're a CGC.
My lord.
Read substantive provision is 7(7) if you are not mistaken. 7 class 7
Yes.
and the rules is 18, Rule 18.
Yes, my lord.
How can you say there is no appellate provision just like that? Mhm. Let's have this.
My lord.
এটা রুলস কোন আছে না? We have not even checked, just see whether we are correct or not. Should be 7-7. Correct?
Well,
And read rule along with rule 18 of the rules. What would be at the memorandum of appeal? Withdraw this, file the appeal.
my lord.
The instant writ petition has been filed by the railways
Railways,
being aggrieved by an order dated 23/8/2022 passed by the controlling authority under the Payment of Gratuity Act 1972. Full stop. Para. It however transpires that under the Payment of Gratuity Act 1972, there is a provision for appeal, which is to be the prescription of which is also laid down in the rules framed thereunder. Full stop. Para. In view of the above, the learned counsel begs to withdraw this writ petition and file an appeal in accordance with law. Full stop. Para. Writ petition accordingly stands closed. Para. Closure of the writ petition is, however, on technical grounds and without affecting the merits.
My lord, this is again a petition for non-payment of contractor dues, my lord. The petitioner, my lord, he was a contractor under the Assam PWD, my lord. And he was, my lord, allotted with certain works, my lord, for the development of the state-of-the-art mortuary connected to the Silchar Medical College, my lord. Thereafter, he had completed the entire work, my lord. That the payment due is already been admitted, my lord. Even then, my lord, he has not been paid his dues, my lord. And he is a, my lord, patient, my lord, suffering, my lord, and undergoing treatment. At this stage, he requires, my lord, the money for his treatment purpose also, my lord. So, my lordship, notice, my lord.
Work was completed when?
Work was completed, my lord, sometime in the year, my lord, 2021. November 2021.
No, 20. Yes, madam. He is suffering from some ailment, serious ailment. Heard Sri G. Chaudhary, learned counsel for the petitioner who has filed this petition for with a claim for release of contractual dues pertaining to construction of state-of-art mortuary building FNSM department at the Silchar Medical College and Hospital. Silchar, ever asylum, huh? Pura itu. Synopsis is wrong ideas. Again. Para, let notice be issued. Returnable by returnable on 30th of September 30. Miss S. Sharma, learned Standing Council Health and Family Welfare Department accepts notice on behalf of respondent of one. One is it?
All the
rest.
No, PWD you cannot take. You'll take. Okay. You are for PWD also. As well as PWD accepts notice on behalf of all the respondents. Extra copies. 2 working days. Upward लिखिए ना. Standing Council Health and Family Welfare as well as PWD. Yes.
May I please, my lord?
Yes.
This matter pertains to non-payment of contractual dues, my lord. The three work orders have been issued in favor of the petition number one company, my lord. Pursuant to the work orders, my lord, we have furnished 1% of the performance security, my lord. Accordingly, after successfully completion of the work orders, the performance security has been
Yes,
released, my
heard
lord.
3B Das learned counsel for the petitioner who is aggrieved by non-payment of contractual dues. Full stop. It is submitted that the work has been successfully completed and even the performance security has been refunded
Yes.
to the petitioner. Para, let notice be issued, returnable by 4 weeks. Ms. R. Bora, Learned Standing Council, Agriculture
1 and 2.
Department accepts notice on behalf of respondable 1 and 2. Finance Department, anybody? R. Bora, anybody? Finance Department? Yes, H. Aliha. R. 3. Extra copies 2 working
ma'am.
days. Yes.
Obliged.
Item?
May I please, Lordship?
Yes.
Lordship, this matter relates to not allowing the petitioners to deposit amount in the Sukanya Samriddhi Yojana account opened for the granddaughter of the petitioner number 1 and daughter of the petitioner number 2 year. Lordship. What happened, Lordship, in 2015 and 2016? Let me take inspection, Lordship. Me a short notice.
Heard Ms. B. Sharma, Learned Counsel for the petitioner who is aggrieved by the action of the respondent authorities in not allowing the petitioners to operate the account under Sukanya Samriddhi Yojana. Full stop. Let notice be issued, returnable by 4 weeks. 3B. Chakraborty, Learned CGC accepts notice on behalf of
All the response.
all the respondents, extra copies 2 working days. Okay. You should settle this matter,
Can be
trivial
settled, Lordship.
matter.
Because
There-
the-
there
because
you
the
go.
new OM has come, Lordship. Only difficulty I am finding
2 and
from
3
the
are
new
declared-
OM, Lordship.
I have also read that from October 1, they will be allowing
Only difficulty is
2
with
and
the
3
new
are the
OM.
granddaughters of the petition number 1.
3 and 4.
3 and-
3 and 4. 2 is the daughter.
Okay, next.
New OM.
Part of it. May I please, Lordship?
Yes.
The petitioner is a registered owner of a
What's the
vehicle,
number?
my lord. Lordship, the petitioner is a registered owner of a vehicle, my lord. The vehicle is
Yes.
the vehicle is fallen down in a canal, my lord. Therefore, he claimed for before the insurance company, my lord.
Hmm.
Insurance company, after verifying the registered surveyor, reported that the vehicle is not repairable, and therefore he communicated a letter to the regional transport officer
Hmm.
for cancellation of the registration certificate, but it was not done by the authority. Instead of cancelling the certificate, asking for the
What-
petitioner yet to approach the authority. Lordship, may kindly have a look at Lordship 55 of
Why didn't you
Matter-
approach the authorities?
Lordship, kindly see the section 55, my lord.
No, have you approached?
Lordship, before what is section provide, my lord? Before, after coming to know that the vehicle is not repairable, before communicated to me, I am coming to learn the efforts that state aspect, my lord. The insurance already communicated to the transport officer,
Now, what is
Thereafter,
your,
those
what is
articles-
your, what is your
I'm-
difficulty?
but we have not received any.
What is your difficulty in approaching along with the recommendation of the insurance?
Lordship, already insurance company informed the authority. Thereafter, we have communicated to me,
See, the matter is yours. Matter is not of the insurance company.
Lordship.
You have to pursue what is your difficulty in approaching the transport department?
Lordship, if, as per the provision, my lord, within 14 days, my lord, but because already,
See, madam, you want your things to be done. What is your difficulty in approaching?
No difficulty, my lord.
And for approach,
Okay.
matter ends there. Tell us
Yes.
the 55
55 2, my lord.
destroyed or has been destroyed.
If a cancellation of registration,
Or then
if a motor vehicle has destroyed.
if a motor has been destroyed or has been rendered permanent, that's a shall within 14 days. Shall within sense report the fact. The owner has to report the fact.
Yes.
Insurance company has done. We are not doubting that. What you also file an application letter and they have got instructions. It's only because of the fact that no formal representation has been given. File a formal representation. We'll close this.
Yes, madam.
Lordship, only thing your
We'll
lordship.
record this. We'll record the
We,
submission.
we have approached your lordship.
Where is the approach?
No, that your lordship, since we have not in writing your lordship, but they insisted on your lordship and a police report your lordship. Now saying that there is an accident. Now your lordship, police says that after 1 month, how can we register a case? Now law does not postulate that there should be an FIR, and it is not a kind of accident where someone gets injuries, your lordship. My vehicle, your lordship, fell down on your lordship pond, your lordship.
What
And
about
then
the driver?
the daughter-in-law was the driver, your lordship.
Daughter-in-law? What vehicle?
Lordship,
What vehicle?
it was your lordship, this is Creta, your lordship.
Okay. Small vehicle. Okay. Okay, you approach.
Lord.
First may dispose of the matter. They may approach the authority with proper documentation
Yes.
as per law.
Heard Sri S. Bota could learn counsel for the petitioner. Also heard Miss M.D. Bora, learned standing counsel, Transport Department. Para,
For as per number 1 and 2, my lord.
Transport. The Motor Vehicles Act 1988 is substantially complied with, as the report has already been forwarded by the insurance company. Para, Ms. Bora, the learned standing counsel, has however submitted that under section for which it transpires that the petitioner owner has not fulfilled his part of the obligation under section 55. What's the para?
Lordship, one more thing. The letter which was issued by the insurance company, we have not received. In
Oh.
fact, the letter was addressed to the regional transport officer, but he is not the regional transport officer, the rescue DTO.
The learned
Consulting
standing
the
counsel has
rescue
also
officer.
informed that the communication alleged to have been sent by the insurance company has not been received till now. Full stop para. Considering the facts and circumstances and the respective contentions, comma, this court is of the opinion that interest of justice will be served by directing the petitioner to furnish, to
Approach.
submit submit an application reporting the fact of the fact regarding damage of the vehicle along with the report of the insurance company, whereafter the authority envisaged under section 55 of the Motor Vehicles Act 1988 would take necessary action and pass a speaking order.
Deeply object, my lord.
Which accordingly stands disposed of. Copy of the written instructions raised by Ms. Bora. The understanding council is made part of the records. You have a copy?
Yes, sir. Obliged.
Deeply object.
এখানে লিখে লই যাও নাহলে মিসপ্লেস হয়ে যাবে হেডিং।
The petitioner applied for a retail outlet dealership under the HPCL. It was reserved for scheduled class physically handicapped candidates. My lord, this advertisement was in the year 2018. I applied under Group 3. Those who have not applied suitable plot of land. Now the opportunity comes to them after exhaustion of the Group 1 and Group 2 candidates. Now in March 2021, my lord, I was asked to provide land. Meaning thereby, if you are able, you will be given a chance for consideration. From March 2021, the lordship is aware, my lord, that the pandemic again started. It was the second year. 3 months time was given to me. Since I failed, again in the month of June, my lord, I was given further 3 months time.
Yes.
The pandemic continued, my lord, until from June, another 3 months, if we consider, my lord, the pandemic remained. In December 2021, I said that there is one particular industrial note which was published in the month of December 2020 for those participants who fell in the previous pandemic, 2020 pandemic. Now, taking the principle of that particular industrial note, kindly gave me an opportunity to offer the land and considering my candidature. That has not been given to me. I have repeatedly been writing.
But is the offer still open?
My lord, that's why
Offer is of
to
2018.
my knowledge, my lord, the advertisement is active, my lord.
Now, look, kindly see the 142, my lord, this is representation, my lord.
1-4?
142, my lord, he has not, my lord, challenged the impugn order, my lord, his rejection order, my lord.
It has been rejected once.
Yes, my lord, 142, my lord, kindly see.
My lord, the emails,
My
both
lord,
the emails I have,
reference, my lord, kindly see. My letter, the 12/9/21, then your email that is showing so declaring my candidates are to be ineligible. That is not challenged, my lord.
the language was such short. I will take your lordship to the emails, my lord. Please,
And my lord, I have given a chart, my lord,
Okay. Oh.
where
You
all
have
the
come late. Why have you come so late?
but, when I have been repeatedly writing to them, there are representations. My
Will it extend the cause of action?
lord, the advertisement is active, my lord. Advertisement is active, my lord.
April of 2018. Is it still active? How are
My
you?
lord, I was given the chance from
as per my
2020.
industrial notice concerned, it is also not applicable, my lord.
Sri P. Bharadwaj, Learned Counsel, for the petitioner who had applied for allotment of a retail outlet
My lord,
in a particular quota pursuant to an advertisement of the year 2018, full stop. With regard to the requirement for providing land, though time was given to the petitioner, comma, the petitioner has cited the pandemic, during the particular period, full stop. Para, per contra, comma, Sriyas Botaku, Learned Counsel, appearing for the respondent corporation has submitted that there is a rejection order, which however has not been put to challenge. Para, be that as it may, let notice be issued returnable by 4 weeks. Free as Botaku Learned Standing Council,
No, my lord.
or Learned Council accepts notice on behalf of both the respondents, extra copies 2 days. The maintainability of the writ petition is however kept open.
Okay.
Yes.
Okay.
What is this?
All the applicants were rejected.
One four.
Ma'am,
Yes, what is this?
petition has been preferred challenging the extension of settlement period law.
Of whom?
Lordship, page 25 is the impugn letter, Lordship, by which settlement period has been extended. It's not permissible, Lordship.
Settlement in favor of whom?
Response number 6, Lordship.
Yes, why have you extended?
So
And who are you?
I'm intending tender, enter tender process cancel, Lordship, and fresh tender is going to be initiated.
Okay. Heard.
My lord, similar order is there, my lord.
Page.
Annexure E. The
Page.
same order,
Page
page 36, that's from my lord.
36. Yes.
And when matter may be list along with those matters, my lord, on 9/9/2024.
Beyond 31/8. Now what is the extension now?
His extension period is granted from 19 to 39. Lord.
39. Today is
In
what?
that, in that case, my lord, lordship observed that already the money has been deposited. Therefore, the 38 was.
Now we'll say beyond 39, you cannot.
Yes, that can be done.
We'll say beyond 39.
That is illegal, Lordship. This letter is
It is already deposited, my lord.
Lordship,
that is-
this,
No, in the last order, which you have annexed.
in that
on-
those cases, Lordship, government notification challenge, Lordship. I have not challenged the government notification, Lord. In those cases, Lord. I have not-
How do you make extension here?
Look.
Allowing them to run on a daily basis, it's a different matter.
Relevation by Ansulik, Lordship, or
My lord,
Ansulik.
that was with a strength of one notification, my lord, issued by government, my. That was stayed by this honorable court, and as the interim, my lord, those who
Ansulik.
approached this court, those markets were stayed on.
Ansulik is allowed to run.
Okay, heard 3 MK Hussain, Learned Council for the petitioner. Full stop. The petitioner who is an intending bidder for the settlement of the Rupohi
Rupee
weekly market in the district of Nagaon is aggrieved by the action of the respondent authorities in allowing, in extending the settlement of the previous lessee, namely the respondent number 6, beyond the period of settlement. Full stop. It is contended that our tender process was initiated on 1/6/2024, which however was cancelled, whereafter the impugned extension has been done. Full stop. The Learned Council has submitted that such extension is in violation of sections 105, 106, and 109 of the Assam Panchayat Act 1994, as well as Rule 47 of the Assam Panchayat within bracket Financial Rules of 2002. Full stop. The Learned Council has also referred certain case laws in support of its submission. Para, let notice be issued, returnable on
Similar matters are pending on 9/9/24.
9/9,
I have not.
Monday,
I have not challenged that notification.
returnable.
He is claiming the interim of that series matter.
No, we are saying this. Returnable on 23rd, short notice, 23rd of September, 2024. 3 SD, 3 S. Datta, Learned Standing Council, PNRD, Department accepts notice on behalf of number
1.
1, 2,
Can you
Three,
take for Naga
4,
Jilla
5,
Parishad?
1 to 5.
One Jila Parishad you can take.
Yes, sir.
1 Tier 2 5 extra copies. R6 registered post AD, 2 working days. Third, the learned counsel on the interim prayer, full stop. After hearing and by taking into consideration the provisions of law, the impugned order dated 29/8/2024 is suspended until further orders, full stop. The respondent authorities can, however, run the market on a daily basis in which the petitioner is also to be given equal consideration.
My lord, till regular settlement.
Wait till the returnable date we have said.
Well.
Pendency shall not be a bar to go ahead for regular settlement of the matter in accordance with law.
My lord, in this case, my lord, respondent number 3 has not passed any speaking order, my lord. And that's why petitioner approached the petitioner.
Speaking order regarding what?
Section 57. Registering authority, respondent number 3, my lord, case 26, my lord. A petitioner's vehicle is locked. Case 26. Locked by Moigao, transferred due to recent police case, rash driving and accident case.
Who has who has not taken the action in accordance with law? Which authority?
Moigao, respondent number 3.
Not the police department.
Oh, Lordship, she is the DPO Bongaigaon. He has logged the registration of the vehicle because there's a police case involved, my lord. This vehicle status is locked, so we need to take instruction.
What has been locked?
Locked, the status is locked. The suspension or cancellation. I think the suspension, Lordship may issue notice, we will get instruction.
Heard 3 A.M. Ahmed learned counsel for the petitioner who is aggrieved by the action of the respondents, more particularly the respondent number 3, who has locked the registration of the vehicle of the petitioner, full stop. It is submitted that the vehicle in question bearing registration number so-and-so Prasailava, bracket Tata Intra, had met with an accident on 13/11/2023, leading to registration of Bongaigaon PS case number so-and-so, under so-and-so, full stop. The victim involved had filed a claim before the MACT Bongaigaon, in which the petitioner had appeared and is contesting, full stop para. Let notice be issued, returnable by 4 weeks. Ms. MD Boral and State Standing Council, Transport Department accepts notice on behalf of respondent 1,
1, 2, 3, 4.
3 and 4.
5.
Yes.
Yes.
OC, Bokolial 5, extra copies, 2 working days.
May not in the meantime, vehicle may not be disposed
Lordship
of.
may not pass an interim
May not
order.
be?
May not be disposed of, my lord, vehicle.
How can they dispose of?
May lord,
It's a matter of 23.
contemplated to
How can they dispose of without an auction or a sale? They cannot.
apply.
Obligation.
If there's any such move, come
Yes.
before us.
Obligation.
16.
Wait, please. But the matter pertains to a contract for construction of the boundary walls with drills in the new Cotton University campus. No?
Yes.
Once the contract was awarded, it was realized that it is such a low-lying area that a approach road of about 600 meters was required to be constructed. So they asked me to go ahead with that additional work. I went ahead. Based on their permissions, my lord, I completed the entire execution of that stretch. And I submitted the bills. They are not releasing the bills. So at this stage, I'm praying for a notice.
Heard 3 I. Chaudhary, learned senior counsel for the petitioner, who is aggrieved by non-payment of contractual dues pursuant to work of construction, এখানে দিয়ে দিবা, হ্যাঁ? Construction of so and so. Full stop. It is the contention of the petitioner that the said work was duly allotted pursuant to an NIT dated 27/7/2022. Para. Let notice be issued. Returnable. Be returnable by 4 weeks. Steps for service of notice upon the respondent of 1 to 6 be taken by registered post with AD. Steps within two days. Union of India, anybody? Union of India, Mr. V. Chakraborty. Who was there? CGC. Sri B. Chakraborty. 4/7, huh? Extra copy.
Obliged.
Item 17.
Very good. But I'm aggrieved, I'm mad, my lord. My lord, in this case, my lord, Coal India, my lord, had invited a notice inviting tender. My lord, it for removal of some overburden, extraction and transportation of coal, my lord, at my lord, Tinsukia. Now, my lord, for that purpose, my lord, a contract was invited, my lord, for a value of about 1,800 crores. Now, my lord, the petitioner, my lord, along with 11 other bidders, had participated in the state bidding process.
12 bidders in total.
12.
Yes.
Now, my lord, out of 12, 11 bidders have suffered disqualification. Now, my lord,
Yes.
I am one of those bidders who have suffered disqualification.
Yes.
Now, my lord, before I take your lordship.
Disqualification in the technical responsive test.
Yes, my lord.
Okay.
My lord. Now, my lord, before I take your lordships to the salient provisions of the NIT, my lord, if your lordship so permits, my lord, may I take your lordship, my lord, to the impugned order by which, my lord, I have been held to be disqualified.
Okay. Your challenge is against your disqualification.
My lord,
Okay.
I am challenging the disqualification, my lord, and
Mr. Datta, you appeared from the Coal India.
Yes, sir.
What is the stage of the contract now?
Now the price bid is open, your lordship.
Opened
Price
already.
bid is
and
open
my lord,
now.
just one thing, my lord, may I just tell your lordship,
Yes.
my lord? After opening of the price bid, my lord, what I find that, my lord, my rate is rupees 112 crores less than that of the single bidder, my lord, who was qualified. So there is an overwhelming public interest, my lord, which is tilting in my favor. Now, my lord, may I just show to your lordship, my lord, that what are the reasons, my lord, assigned for disqualifying me? My lord, kindly, my lord, take the pains of coming down to page 205.
205, yes.
Lord. They had sought for a clarification, my lord, on 16/8/2024 by way of mail, to which I give my reply on 17/8/2024, the following day. And my lord, now, my lord, kindly find, my lord, the reasons, my lord, at page 205. Am I with your lordship?
Yes, yes.
I'm so grateful. Now, my lord, as the documents of the local content submitted against the clarification is dated 17/8/2024, which is after the bid submission end date, that is 5/8/24, and the submitted document regarding construction agreement is not in line with the format provided at Annexure 2 of the so-and-so the bid document. Therefore, you are not fulfilling the eligibility criteria as per requirement of the bid document. So, my lord, this is dated 22/8/2024. My lord, what I would point out before.
Where do you get the date?
My lord, at the left-hand side.
Okay.
I'm grateful, Lord. Now, my lord, kindly take note of this date, 17/8/2024.
Your reply.
Yes. Now, my lord, may I take your lordship, my lord? So they are, in fact, my lord, primarily they are assigning two reasons. That, my lord, it was not, my local content was not in conformity with the tender document, and that my consortium certificate or consortium agreement did not conform to the provisions of the agreement. These are the two grounds, my lord, assigned.
Yes.
Now, my lord, kindly, my lord, see the relevant clauses of the agreement. First of all, my lord, the NIT, my lord, starts from page 51. Please take the pains of coming down to 52. Para 1,
Just a minute.
I'm sorry.
I did not get your name, please.
I'm Shomik Dev.
Okay. Mr. Dev, we'll do one thing. What is the stage
Now the price bid is open.
thereafter?
It is in the stage of the director of finance. They are considering and they are verifying their the L1.
Don't you issue the work order.
I'm
You obtain the instructions.
Yes, but they could not be say because
No, we are giving a very short date. We are asking them to furnish, take steps on the private respondent by Dusty.
My lord, we do that, we do that. Just give that.
Mr. Ahmed?
My lord, only one indulgence I'd be praying for, my lord.
Yes.
If your lordship doesn't fix the matter, my lord, on 30th of September. Just that is the only date, my lord.
We are having a very temporary kind of you take instructions, don't issue the final work order. He is making a case, trying to make out a case that his rejection in the technical round is not in accordance with law. How far he'll be successful will be based on the instructions which you have. But the successful bidder will not have any say in this. But nonetheless, it's a party. So we'll ask Dusty steps to be taken. Okay.
My lord.
Third, Sri S. J. Blanet, Senior Counsel for the petitioner, who is aggrieved by the rejection. One more matter, Mr. Ahmed. If out of 12, 11 of the bids are held to be technically non-responsive, how can you go ahead with one?
My lord, this is the plea, my lord, we have taken by referring to clause 4.17 of the
There will be
CVC
no-
guidelines.
I think there'll be a CVC guidelines, at least one attempt you have to make
Mother-
thereafter.
And also the procurement manual.
that is allowed. That is allowed.
Okay,
Page
okay.
number 29.
Learned Counsel for who is aggrieved by the rejection of its bid pursuant to an NIT floated by the Coal India Limited for so and so. Huh? It is submitted that vide the impugned communication dated 22/8/2024, the technical bid of the petitioner has been sought to be rejected. Full stop. It is submitted that upon opening of the financial bid, comma, it transpires that the financial bid offered by the petitioner is substantially less.
And
there-
12 crores less.
is substantially less,
My lord.
and therefore there is an element of public
My
interest.
lord, I'm so grateful.
Full stop. The aspect of going ahead with one single bid has also been highlighted by the learned counsel for the petitioner. Para, let notice be issued. Returnable on today's 6th. We'll have it on 23rd. 23rd. 23rd.
My lord, the private respondent is from Gujarat. We would take steps through court as well as Dusty, my lord.
Yes.
My lord, that permission. if
Yeah,
your
that
lordship-
Dusty we are saying.
My lord, I'm so
Otherwise,
grateful.
21st will not be
Because otherwise
Sri
not-
Ministry of Coal, CGC. Mr. Sri S.S. Roy, learned CGC accepts notice on behalf of respondent number 1 and 2. Sri A.M. Datta, learned counsel assisting Sri Ahmed, the senior counsel for Coal India, accepts notice on behalf of
3, 4, 5.
respondent numbers 3, 4, and 5.
My lord.
Extra copies, 2 working days. Para. Let steps be taken for service of notice upon the respondent 6 by registered post with AD. Additionally, Dusty, steps by Dusty are to be taken for service upon the said respondent number 6, which is, however, required to be routed through the registry of this court.
My lord.
The notice accompanying the Dusty would clearly reflect the next date fixed which is 23/9/2024, and prior to the said date, the petitioner is required to file an affidavit in proof of such justice service.
My lord.
Para. Sri Dev Dilan Senate Council prays for an interim order. Para. Considering the facts and circumstances, and also being apprised that the work order is yet to be issued, comma, it is provided that till the returnable date, no final work order be issued in respect of the work in question, full stop. The present order being passed ex parte qua the respond number 3 and without affording the instructions to be taken, comma, the same would be reconsidered on the next date.
My lord, by the next date, they would file their affidavit, my lord.
We'll file the matter.
Okay. 23rd.
My lord, I'm so great. Gentlemen.
At 10:56, something is.
May it be the lordship. The brief facts of the case is that the Regional Provident Fund Commissioner lordship is
Item number,
item 56 lordship. The staff show-cause notice upon
you
the
had mentioned this matter yesterday.
yes, yesterday.
এইদিকে থৈ দিয়া না?
Staff show-cause notice upon the
Mistake হয়ে যাব না? এইখানে থৈ দিয়া এখানে। এখানে থৈ দিয়া। You are aggrieved by what?
lordship agreeable with the lordship kindly come to the annexure 16. I received an SMS from my bank on 2nd
You
of
are Tinsukia Municipal
Tinsukia
Board.
Municipal Board lordship. After lordship proceeding drawn under 7Q and 14B, an outstanding amount of payment of rupees 85 lakhs is due. And we are ready to pay, but before that lordship, against that impugn order, we prepared an appeal. Now during pendency of that appeal, as well as without serving
Appeal
any
before where?
before the authority lordship, CG lordship. Now, without serving any notice under section 8F31, notice is mandatory to the employer. So without serving any notice or intimation notice, the amount for an amount of rupees 85 lakh that has been kept on hold. So because of this lordship, we are facing equal hardship because we are unable to pay our salary to our employees. There are now 70 numbers of employees. Now Puja is also forthcoming lordship. So
So
because
why
of
didn't you pay the amount?
lordship,
Pay the amount, then the dispute
no,
will be.
that I have said it since the appeal is pending.
No, there-
Because in the, there is a provisional lordship, they can waive or reduce the damages lordship, amount of damages.
But you pay a certain amount, if not the entire.
Already we have paid the interest amount, 58 lakhs already we have paid, that they have admitted also.
See, these are matters, statutory obligation. You cannot just, you may have some, make out some case that you may not be, the amount is not correct, but
Lordship-
assumption is always in favor of the.
Lordship kindly see the impure order. The impure order lordship will find it,
How much is the due now?
due
According to-
85 lakhs 79,376.
Yes.
So already we
Mr.
have
Dev,
paid,
Lordship, page 26, Lordship. In 8, page 26, Lordship, and I. The 3, Lordship,
26,
and 3, Lordship.
yes.
Yes, that's it. Meanwhile, the calculation of the contribution in the aforesaid heads for the period of January so and so, but due to shortage of the working staff, the work could not be completed, and as such, we failed to deposit the backlog EPF contributions so and so. If they admitted, then Lordship, please come page 29.
How much will you pay, Mr. Decker?
lordship, installment wise we can pay.
No, not one time now.
No, one, because lordship, the puja is for,
No,
at least some time is required, lordship. We are not denying,
but-
already,
see,
lordship, kindly
these-
appreciate one thing, lordship, already we have paid
There
58
is
lakhs.
no scope of appreciating in EPF matters. It's a statutory liability. There,
No.
it is very strict.
See, if the admitted facts of
These,
we are,
these have passed the test of
lordship, we are
judicial
not
scrutiny.
denying that we are.
So how much are you
we are
going to pay? How much are you going to pay?
So let me think after some time, lordship, I mean, the
You
instruction-
pay half of the amount,
let me
half-
have the instruction.
half of the
After
amount,
some time,
then you at least
because otherwise,
take
lordship, there are
instructions.
the one hand, lordship, kindly the appeal is pending. It is statutory appeal. And the
Statutory appeal, doesn't mean that you are not-
notice is required, it's a mandatory requirement. Section, lordship,
See,
kindly
Mr.
have,
we have
lordship,
not
kindly
got
have
to-
the act, lordship, for a moment, lordship, for my satisfaction.
The notice is
You
writing
take
is.
instructions, how much you are going to pay.
Lord.
These matters will not entered in. These are it's contribution which you have to make.
No, we are ready
Yes,
to.
come up with instructions, 50%. Yes, next,
Then what mathematics act 2 Lord.
after some time, whenever you come.
But let me have instruction.
Yes.
Act 2
You
Lord.
come before that.
Lord. Oblige.
55 to আহিল নেকি withdrawal to?
Eight
মই যে
reason
লিখি
Lord.
থৈ দিছিলো, আহিলে কোন আহিছে? আচ্ছা। আৰু হেৰি
Matter
উপাধ্যায়
pertains-
আহিলে নেকি? এছ উপাধ্যায়। অ',
The matter pertains to disconnection of power supply without issuing any notice and without giving an opportunity of being heard. The petitioner lordship is the wife
what is
of
your
the
name?
M.R. Chaudhary lordship. There is a limited prayer lordship for reconnection and to provide us with a notice and
President of
opportunity of
MRG Rupnagar Kondan. There may be some pending dues.
There is, but I must point out, well,
Why didn't you pay the pending dues?
there's no pending dues. Now, what has happened is, what they've suppressed, I'm sorry to say that, there's been theft of electricity. There's a FIR
We have-
pending against them. These are the instructions. And when the officials went to visit the premises, they were assaulted by the petitioners. Now they're trying to make up a case that there's been disconnection without any rhyme or reason.
Your lordship may kindly speak.
They've been
paragraph
served with
3,
an
lordship.
assessment, let them pay the amount, then the reconnection can be carried.
Heard Sri M.R. Chaudhary Learned Counsel for the petitioner. Full stop. As per the projection made in the petition, comma, the grievance emanates from disconnection of the electricity. Full stop. It is contended that the petitioner, along with her family is there or not?
Lordship,
Family
all of them are
Are-
mental patients,
are-
lordship.
are consuming electricity on the strength of a connection which is in the name of her husband. Husband is there or not?
Yes, lordship. He is a mental patient, lordship.
He was the one who was assaulted.
A husband who is said to be suffering from some mental ailment.
Right.
Full stop. Para. Sri B. Chaudhary, Learned Counsel, appearing for the
Responding on 2, 3, and 4.
APD. APDCL has, however, submitted an instruction that there was a case of theft of
Yes.
electricity, which was reported, and when the officials, public personnel, had visited the site, they were also assaulted, leading to lodging of further reports. Full stop. The Learned Standing Council, however, submits that in the event the outstanding dues are paid, comma, the other aspects, comma, the electricity line would be restored. Full stop. Para. We can dispose this.
The
Okay.
page 4 of the instruction.
Okay. Para. The rival submissions have been considered. Full stop. Para. You have made the assessment
Yes, the assessment is done, there is a bill at page 4.
as per the. Are you aware of this bill, Mr.
No,
Chaudhary?
they've been served,
Yes,
they
sir.
refused to,
Uh,
as per the use.
Then we'll not do the rival submission. We'll issue notice. Rival submission notice. Let notice be issued, returnable by 4 weeks. Sri Chaudhary, Power Department, Bukulyal, number 1, R1, 2, 3, and 4.
I'll-
B. Chaudhary, APD, Standing Council, APDCL, extra copies. Para. Heard the Learned Counsel for the parties on the interim prayer. Full stop. Para. As per the written instructions, comma, an assessment has been made for the dues involved. Full stop. It is accordingly provided that in the event the assessed amount is paid, public deposited, comma, the electricity connection would be restored, full stop.
If the amount is high, we may be allowed to give on installments, Lordship.
That is not permitted. How much is the amount?
So it is 63,000, but there would be compounding interest on that. So it would be somewhere in the region of 88 or 85.
But still pay one installment provisionally, the line may be connected. All three of them are mental patients, Lordship. Except for the petitioner. They all have to break.
The interim prayer, full. As per the assessment order which has been placed on record, the due appears to be about rupees 60,000,
63,000.
63,000. And it is also contended that the said amount would accrue interest
There is the compounding rate.
on compounding, would accrue compound interest, full stop, para. Considering the above, and the learned counsel for the petitioner has emphasized that 3 of the inhabitants of the premises are suffering from mental ailment, full stop. Considering the above, comma, it is provided that the petitioner would deposit an amount of rupees 30,000, and on such deposit, comma, the electricity is to be restored, full stop. On the next date, this court will consider passing of further orders depending on the developments.
Then may I pray for it to be fixed?
Yes, at least on, you fix the date. Today is 6th, we'll have it on 25th. If they do not deposit, no need of connection.
Obliged, Lord.
Regarding non-payment of balance amount of the contract deal law. Balance amount of 53 lakh 32,415. Total work value was 3 crores 49 lakh 44,595 for the construction of ICBP road from Kaliaganj to Amguri via Lakhipur under 5th.
When work order, which year?
Work order was during the 2018-19. Lordship will find the work
Completed
order
when?
at page 16.
Completed when?
Completed. Lordship.
When?
Yes, Lordship. Completion certificate is there. At page 25. Completed on 13/5/2020.
20. Why are you so late?
13/5/2020, Lordship.
You're
And the
not
work
late.
order was issued.
35,
during
2020, you're not late.
I have paid.
You're not late in
Lordship.
coming to the court. We asked, why are you so late? You said, I paid him to.
No,
Work
they
on
have
2020.
paid, admittedly, they have paid 2 crores 96 lakh 12,180.
Yes, madam.
Lordship, this work is regarding construction under Assam Fifth Assam State Finance Commission during 1894. Earlier, item 5 and 6 also same period, Lordship. Here, Lordship, in paragraph 4, he has stated some contract agreement. He has not annexed that contract. Perhaps there might also
Very admitted, Lordship.
some.
Mr. Dhawar, we have remitted 2 matters for arbitration because of some certain observations made by this court in earlier orders. You take instructions.
During 1819.
You take instructions. You take instructions. Heard. 3 R. Third learned counsel for the petitioner who has filed his petition claiming certain contractual dues. Full stop. Para. Ms. R.B. Bora. Learned counsel. Learned state counsel. Learned standing counsel. BTC has, however, informed that in respect of certain writ petitions, comma, the matter has been remanded for a dispute redressal mechanism by arbitration as provided in the contract in question. And this contract appears to be of the same period. Full stop. Para. Let instructions be taken in this regard by the learned Standing council, please for motion on 16th of December, September. 16th September.
Thank you.
You take to today's order copy also.
That petitioner is a contractor by Malad. He was, Malad, the IOC had granted Malad a contract Malad for construction of a canopy. In a B site, Malad, there are two types of sites Malad in the arrow. One is A site, which is the company owned Malad the depot, and B site is the privately owned Malad. They are the construct character Malad, it is to be maintained by the owner of the. And here Malad, the construction was completed on 20th of January 23. And a third-party inspection was appointed Malad by the IOC, inspected the same, and thereafter engineer charge cleared the same. Final bill was issued, and defect liability period was also completed on 21/2024. Now, on 20th April, my lord, 24, there was a huge thunderstorm in the area, my lord, and many trees were uprooted, houses were destroyed, roofs were taken away, my lord. Many vehicles were damaged. In that, my lord, the canopy fell down. And thereafter, my lord, they got the same inspected for their own team and said that there was some defect in the metal.
Oh, third Sri GN
Hello.
Sahavala, Learned Counsel, Learned Senior Counsel for the petitioner who is aggrieved by an order dated 22/8/2024, by which the petitioner has been placed on a holiday list. Full stop. It is submitted that the basis of the impugned action is non-existing, and even the procedure adopted by getting the investigation done by an internal committee is not in accordance with law.
And no hearing was given, my lord. As per now,
Show cause was given to you.
My lord?
Show cause was given.
shock was, but nowadays Supreme Court say, my lord, hearing is to be given. Because it's a civil death.
No, it depends on the case.
Nowadays,
Normally,
I've got the
normally,
judgment, my lord.
let notice be issued, returnable, and no standing counsel.
My lord, they are
Returnable.
not standing, my lord, they are given after notice, my lord. They have not.
Returnable on 25th of September 2024. That steps be taken for service of notice upon the respondents by registered post with AD steps within 2 days. The prayer for interim order would be considered on the returnable date.
Till then, my lord, because your losses may see, my lord.
We are that is where we are fixing on
Hearing is
25th.
a must, my lord, nowadays.
On 25th.
My lord, your losses may just see, my lord. The judgment, lord.
25th we will consider. 25th. Let them come. You can also serve upon some certain counsel who normally appears for IOC. If
Well,
they-
I wanted to start, my lord, they say that only notice, my lord, go there. after, my lord, there.
then ensure that the notice is served. Because we are fixing an early date, 25th.
My lord, can it be by the service?
On Dusty, okay, steps by Dusty upon the respondents is also permitted, which is however to be routed through the registry of this court and in the notice accompanying the Dusty, comma, the next date is to be clearly reflected. Prior, not para, stop. Prior to the next date, the petitioner is required to file an affidavit in proof of such justice service.
May it the IA 3164 filed by me. The page is interim order is at page 22.
You're for,
It's
comma
number
for
9.
stay vacating.
David.
Okay. Objections filed.
Objections have been filed, but in connection with this issue, a division matter writ appeal is pending. If I may just summarize the point submitting below. The secretary was suspended. He filed a writ petition. But before filing the writ petition, he was terminated. That was suppressed in the writ petition. Writ petition was disposed of at the open stage ex parte. Now we file a writ appeal challenging that we ought to have been heard. If we would have been heard,
Now, what is your cause of
My
action
case
here?
is, my lord,
No, no.
at present,
You're the private respondent.
I am the private respondent.
No, no,
to
just a minute. Mr. Bonik, what is your case before us?
Departmental inquiry, that inquiry report is under challenge by here, where they have exonerated me under the departmental inquiry. They have exonerated me of the charge. They have gone to the writ appellate court challenging that single bench order which allowed for an inquiry. And that is there, they
No.
say, please, let me finish, then you say. They have challenged where the London single judge held that the suspension order is honest in law and there should be an inquiry. Now they say in the writ appellate court that they have suppressed that before that you have challenged the suspension order. You have
Mr. Chaudhary, you have filed affidavit in the main case.
in the main case, my lord, we have filed an IA. My whole prayer is that
Just a minute. Can we treat your IA to be an affidavit?
it can be an affidavit.
Then we'll hear this matter.
My lord, I place it
Early
that
next
way, my lord. My friend will also suggest that way. But I concede
next
to the
week.
fact. I concede to the fact that let the matter be again sent for inquiry by the under section 38 to 49 of the Cooperative Society Act by the present Board of Directors. That is their prayer. They let the inquiry be again held by the Board of Directors. Present Board of Directors. What is the problem, my lord?
What is your prayer in the writ petition?
That is the prayer. The inquiry is bad in law.
we have challenged the inquiry report in the writ petition. The challenge, amongst others, is on the ground that the Honorable High Court had
Now we'll direct that whole hog new inquiry.
New inquiry by the present Board of Directors
but
under section 38 to 49.
with an observation, Miller, this has nothing to do with regard to the fact of termination of the respondent number 9. That observation, because that is the crux in the division means matter. That observation is nothing to do with the termination or otherwise of the.
No, that is not even the subject matter.
That observation needs to be done tacitly, otherwise it might be a different cause of different supporting limb of argument in the division bench.
Agreeable?
My lord, to the fact that the order by which the order under challenge by the division in the division bench is at page 42.
Now, Mr. Roychud, Mr. Bonik, we are not going to say anything more. Come to the prayer at page 17, 18.
No.
What Mr. Roychud has said, that he is aggrieved by the inquiry report of 21/11/2022 and the impugned order of 24/3/2023 based on the inquiry report. We send back the matter for
To the present Board of Directors to decide the matter. Finish. That much.
No, the direction was not to the present Board of Directors. This
Why?
inquiry is flowing. This inquiry is flowing from a judicial order. The judicial order by
No,
the.
who will make the inquiry?
My lord.
Judicial order is okay, but who will make the inquiry?
Absolutely. There should be a re-inquiry. That's not an issue.
By the Board of Directors.
The Honorable Single Judge had directed that a particular officer would take all of this and appoint an officer to inquire into the matter, not the Board of Directors. Accordingly, at page 68, Lordship takes up the matter. Page 68.
No, we,
Therefore,
if you
it's
are
not by the
considering,
board.
if there,
But
if
the
there,
law says, my lord, the law says
Not by the
board.
board. This is never under challenge by them.
The law
They
says
are
the
enjoying
board.
the inquiry
no, no,
report.
if there are contentious issues, we'll have it on Tuesday.
Section,
Lordship,
Tuesday for final orders.
because 38 says, my lord, it is
they
by
are
the
enjoying
power
the
of the
inquiry
board.
report. They cannot have it the other way around.
Tuesday, okay.
Obliged.
Heard, Shri P.K. Roy Chaudhary Learned Counsel for the applicant. Respondent number 6.
9.
Also heard Shri S. Bonik Learned Counsel for the opposite party, writ petitioner. Para. Considering the subject matter involved, let the IA as well as the writ petition be listed for consideration on, we'll have it on Tuesday, on 10th.
Yes.
10th September. As walked, that is, Standing Council Cooperation Department is present.
Well,
We add one more line, Mr. Roy Chaudhary. The IA file for IA would be treated as an affidavit in opposition.
then the interim order be extended.
In the IA treated an affidavit in opposition. Interim order passed earlier, stand extended till the next date of listing.
All right.
This matter related to the fair price shop in the Jara area of the Kokajar district under 50/50 right. Other party is trying to produce the license, the distributing name of the restaurant number 11. And the petitioner is running the fair price shop in the 250 area and the Samavai committee in the district of Kokajar. That is, but suddenly in 2016, the respondent authority, named the respondent number 9, superintendent, he had issued the under order directing allowing respondent number 11 to hold the fair price shop on the ground that there is a complaint against the petitioner as per as to a proper distribution of the essential commodity allotted to him for the purpose of distributing among the consumer item.
Here for R11, Mr. Mannan, R11, R11, R11.
Basically, I'll rely on the government's.
Mr. Abha for,
This matter, my lord, R.K. Mukhtari was the petition. He is out of session, my lord. However, my lord, instruction is right here. By order dated 6/6/2020, council was instructed to, directed to take.
you have the instructions? What there? Yes.
Yeah, my point is, my lord, if on the license of issuing the emperor from the 11 on the ground there, there's a complaint against me.
Yes,
But if my petitioner, so many consumers, setting a commodity from the source of the petitioner has highly representation and it's not true that there is a proper distribution of the commodity by the petitioner. So if there is an allegation was made, the inquiry should have been made. I should have been given opportunity to bring her my lord. So the order passed without giving the opportunity to bring her. It is complete violation of the principle of.
This is not the instructions, Mr. Abha, this is the
My lord,
license.
my lord, the affidavit in opposition also is.
This is the license, right? What do we do with the license? Photocopy of the license. I to go right about Chandan.
Principle national justice is violated and secondly, license are issued.
Now, are you equipped with the facts? If you are equipped with 2016 matter, we take it up for disposal right now.
My lord, R.K. Mukhtari was that thing.
11 Monday next. 16 matters, no point. Mr. Sharma, on say Monday?
On Monday.
Okay. Heard K. Sharma, learned counsel for the petitioner. Para 3. S.R. Rabha, learned standing counsel BTC, has however submitted that the matter has been entrusted to his colleague Sri R.K. Musari, who is out of station. Also heard Sri Mannan, the learned counsel for the respondent number 11. Para, in the interest of justice, list for admission on Monday. Item number, itu gimana sih? Gimana sih item? Monday.
Monday. Okay, matter may be passed for a time being. Maybe taking it seriously.
21. Time being is not possible. Affidavit filed on a 19 matter. Yes, who is appearing?
Knowledge about the case.
Mr. Gogoi? No affidavit filed.
I'm for respondent number 4, 5, and 6.
On a prayer made on behalf of the petitioner. Matter is adjourned to be listed on Wednesday next. All matter, Wednesday come up.
Wednesday.
Yes. Date, huh? 22 to Hari hoise na? Yes, where is your colleague?
Oh, my lord, yes, mistakenly, my lord. Because your lordship was sitting the bench 3 on the last week, I think, or this week also, I think, the bench 3 matter. So I have informed him there is a bench 4 matter. So we have a mistake, my lord, there.
You don't make this kind of
Yeah, no,
mistakes.
sorry, my lord, very sorry.
Whatever you say, we take it on face value.
Yes, yes, my lord. Actually,
Yes.
my lord, I thought that your lordship is sitting in bench 3, my lord. So here is the matter, my lord, the long affidavit they have filed, my lord, the respondent. Some reply, my lord, I have long affidavit, big affidavit.
Long lordship, because I have annexed the.
Long affidavit has been filed long time
Yes.
back. In
Yes,
February.
my lord, of course, my lord.
February
They have denied.
2023, not 24.
Yes, my lord.
Your
They have-
long reply should have come by now.
Yes, they have denied them. They denied it, my lord. My lord. So we have to just 2-3 days, my lord. Next week I'll.
You have not done for 1.5 years. How
my
can you
lord,
do in 2 days?
I agree, my lord. Next Wednesday, before Wednesday, my lord, I will file, man. If your lordship allow, the Wednesday.
What is the subject matter?
This is, they are asking for contract agreement lordship, but my case is that there is an arbitration clause, and as per that, the jurisdiction is also Aizawl High Court, and there is a specific
Aizawl High
arbitration
Court.
clause. Yes, lord.
Is there Aizawl High Court?
Aizawl bench of our High Court. Because the place of occurrence is at
No, that may not be a very strict thing, but if the
Lord,
arbitration is
December
if you're espousing that there's an arbitration, then that may be a serious issue. Whether it's filed in the Aizawl bench, that may not be very.
But arbitration clause is there.
Okay.
My affidavit of December 2019.
No affidavit in opposition has been filed way back on 17/2/2023.
No, lordship, that is additional. Main one is of 2019 December.
Oh my God, 2020, 16/11, 6/11. Only 4 years.
I agree, I agree.
Only 4 years.
No, before, in the middle, my lord, Corona has come, my lord. Totally, my lord.
Corona, who is Corona?
My lord.
Oh, Corona
From
has
20,
gone.
no, 2021 or 22.
Corona came, Corona gone.
Gone, my lord. So that's why, my lord, the matter, my lord, just, my lord, remaining like that, my.
No affidavit in opposition was filed in the year 2020, followed by an additional affidavit in the year 2023, comma. No rejoinder has been filed. Full stop para. Shri B. Sinha, learned counsel for the petitioners submits that a rejoinder would be filed within a period of a week from today.
Yes.
Full stop para. List on 17th of September. You get more than a week, no further time.
Yes.
17th will dispose this of whole matter for admission.
Yeah, please, Your Lordship, the matter is passed over for the day. Actually, Your Lordship, we are not having any contact or any instruction from the petitioner, so we have tried several times. We may withdraw the Wakalatama out.
Now what?
We need some time, Your Lord.
Just a minute. Your Arkumar.
Yes, sir.
Sri Arkur, learned counsel for the petitioners. Full stop. On the last occasion, 22/1/2024, time was granted to the learned counsel to obtain instructions. Full stop. It is submitted that in spite of best efforts, no instructions could be obtained and the clients are not in touch. Full stop. Para. Also, Sri S. Datta, learned standing counsel, PNRD. Full stop. Para. In the interest of justice, consideration of this matter is deferred by a week. Full stop. It is, however, made clear that in absence of any instructions, this court would pass appropriate orders. List on 13th September.
If, will be time, more time.
No, we had given time earlier. It's only to ensure that somebody may appear or may not appear, otherwise we'll go ahead. 13th September. Yes.
Okay, I have talked with my client lordship. Okay, considering our financial constraint, we are ready to pay now right now 20 lakh lordship. And rest of the amount lordship after the vacation. In the meantime, let the authority dispose of the appeal. Because there is a provision to reduce or waive the damages lordship. So there may be possibility.
How much is the due and how much is the damage?
85, no, 85, right? 85 lakh 79,370.
That component is what? Enter dues.
Because lordship kindly see the
Yes,
Yes,
Mr. Dev.
it is from lordship, this is that there is a reason why lordship we have not deposited.
The reasons will not help. EPF.
We already there
EPF.
it is deposited in the other account. Before lordship registration under the EPF Act, we have deposited that contribution in the bank account of the our client employee. Now, after registration in 2016, this act in fact came into force with effect from 2011. But that notification never intimated to us. So that is why we have not deposited the amount.
Yes,
But
this is what
thereafter
you
we
say.
registered. That is our specific, and they have admitted also.
What do you say, 20 lakhs?
So that is up to the Lord, because a big amount, 85,000.
We are ready to pay, but because of our financial constraint, lordship.
Heard Sri Deka Learned Counsel for the petitioner who is aggrieved, petitioner, first of the petitioner, which is the Tinsukia
Municipal
Board, is aggrieved by
Impugn order, lordship will find at page. No.
by an
Annex 8,
order
page
dated
40.
2010-2023, whereby an amount of rupees 85,79,376 has been directed to be paid against damages and interest under the Employees Provident Funds and Miscellaneous Provisions Act 1952. It is submitted that an appeal has been preferred on 13/3/2024, which is yet to be considered. Para. Let notice be issued. No. The Senate Council submits that the authority has the power to reduce or even waive the damage, and otherwise also the petitioner is ready and willing to pay the actual amount, and only because of certain financial constraints there is delay in payment. Para, let notice be issued, returnable on 25th of September. Sri D.K. Day, Learned. You are for Standing Council?
224.
Standing Council. Union of India.
Union of India. P. Chakraborty, I will inform him. Morning he was present. Lord.
Anybody, any CCC in the court? Sri B. Chakraborty, Learned
I
CCC
will
accept
inform.
notice on behalf of respondent 1. Sri D.K. Day, Learned Standing Council. EPF accepts notice on behalf of respondent 2, 3, 4.
So
Five
notice.
extra copies, huh? Steps for service of notice upon respondent 5 be taken by registered posted daily. Steps within 2 days. Para. Third, the Learned Council on the interim prayer, full stop, para. After hearing, comma, it is directed that no coercive action be taken pursuant to the impugned order dated 9/4/2024, subject to deposit of an amount of rupees 20 lakh for the present by the petitioner within a period of 10 days from today. 10 days within a period of we are fixing when? When are you fixing next date? Or the period of 10 days from today. Full stop. It is also provided that pendency shall not be a bar for consideration of the appeal.
Because so far the amount, we will be allowed to utilize that amount Because from that amount, we have to pay the salary to my staff, the bonus as well as the incentive also, and salary part mainly.
That,
So we may be allowed to utilize that amount.
that we'll consider on the next date.
No, already we have paid, otherwise, let's say, the entire amount is in my that bank account, let's say. From that, we are paying salary to my staff, employee. And from
The
that,
bank account is frozen.
no, that the HG also kindly have annexed 16 page.
Is it frozen
55.
or what?
Not frozen,
Yeah.
the amount is whole. So once the
That is
this
frozen. I
amount
think.
is whole, we cannot utilize this amount. Now, the amount which we are going to pay is 20 lakh, we have to pay from this amount, because otherwise we have no fund otherwise. So that way we may be allowed liberty given to utilize this amount.
Page.
Page 16, annexure 55. This is an SMS from my concerned bank. First, kindly see to 2nd of September. Dear customer, whole has been placed on your account number so and so for rupees. This is the damage amount, 85 lakh 79,376.
It is also directed that the decision of the respondent number 5 bank
Yes.
to put on hold the account would remain suspended till the next date of
Yes.
Till the next date fixed.
Deployable. Deployable.
You only have 85 lakhs in your account.
10 50 lakh also.
Huh?
10 50 lakh, near about 1 crore loss, because otherwise 85 lakh is holding. So from 10 15 lakh we could not provide, because otherwise we have to pay within 10 days 20 lakh. Now
It
from
is also
this,
provided that accept the salaries for the employees, no other withdrawal can be made by the petitioner during the till the next returnable date.
salary, the amount as well as the amount of that 20 lakh.
20 lakhs is
Obliged. Deployable.
salary and the amount of those 20 lakhs directed to be deposited.
This is a fishery settlement matter, my lord. Pleadings are otherwise complete. Your lordship may perhaps have it on a hearing day. 24 to 26.
Yes. Which date tell us?
There is no interim, my lord. Can it be on 1st? If necessary, we'll adjust.
1st of what?
1st of October, it's a Tuesday.
No, that last week will not be possible.
That is also true.
On 22nd October.
20.
Reopening, we are reopening on 21st, 22nd. No adjournment. Heard Sri I. Chaudhary, Learned Senior Counsel for the petitioner in WPC, so and so, Sairu. As well as Miss D. Borgohai, Learned Counsel for the petitioner in WPC, so and so. 3 petitioners, one more. Who you're representing 2?
Yeah, 24 and 26 I have.
3. Miss MDB, Learned Counsel for the private respondent is present. Fishery Department, M. Chetia, State Counsel. Para. Bleedings being complete and the matter pertaining to settlement of a fishery, the same will be listed for admission hearing on 22/10, 22nd October. Yes, we'll give the name.
My lord, petitioner was given a carriage contract, my lord, in the abstract. My lord, in the tender, my lord, the distance was given as 292 kilometers. My lord, we have put it there, my lord, and if your lordship will see the page 74, my lord, there also they have said this telegram by which, my lord, our settlement was granted. It is 292. Now we, my lord, we found that road is, my lord, more, my lord. So we submitted several.
The distance is more.
Several representations, and thereafter they have appointed a committee. A committee found, my lord, that the distance is 343.2 kilometers.
Yes.
Then, my lord, we demanded that that was not paid, so we approached this honorable court. And this honorable court, my lord, allowed the same, my lord. Single bench. Division bench, my lord, they filed an appeal. Division bench said that there is a grievance redressal commission. So the grievance redressal committee should propose first, my lord. We approached the grievance redressal committee. They arbitrarily rejected the same. We approached this court again. This court said that you have not considered this because the distance is more. That is to be clear. Then again, it was sent back to the redressal committee, my lord, to pass an appropriate order. This time also again they have rejected. In fact, my lord, this is covered by two division bench judgment of our High Court, my lord. I'm just reading.
Mr. Singh?
Senior friend has completed, then I will.
No, he's not completed. Is it covered by a division bench?
I will defer, my lord, because the division bench of this honorable court, in this case only, that has been annexed as annexure 21, my lord, page 114.
My lord, in the
In
past,
one KB Chaudhary matter, matter has gone to SLP, my lord. Here, there is another committee, my lord, they subsequently been, they have inquired it and the distance is found to be 290 kilometers. Now the question is disputed question of fact. On that
Now, if
executive-
in the first round, when the writ petition was allowed, you had gone on appeal, you said that there is a dispute redressal committee.
No, my, first of all, the honorable division bench has stated that will not enter into the disputed question of facts and recalculate the rate. And then the petitioner has opted for going for the GRC, then they went to GRC. GRC has rejected the claim. Again, they have approached this honorable court. Honorable court said that on the very most state that it doesn't seem to be reason order, you kindly reconsider it. That I have agreed. And then after reconsideration, it has already been again been rejected. And thereafter the FCA has made an inquiry by constituting another inquiry committee, my lord. And in that inquiry committee, it has been found that the distance 290 kilometers, not 334 kilometers as stated by the earlier inquiry committee. Accordingly, we have taken action against those hearing officer, my lord. Now the question is that after this new inquiry committee, my lord, has been found at 290 kilometers that my learned friend is referring. So now the disputed question of fact, let them approach the civil court, my lord.
my lord, your lordship will see, my lord, in the first readable judgment, paragraph 11 only, page 7, my lord. That my case was also there.
Paragraph?
11. My case was also referred to in this judgment. That being the position, my lord, the earlier writ appeal has been considered here, my lord, the second one. And thereafter, that being a position, FCA cannot change its stand and act in contravention of its own decision. The division bench judgment in the case of so and so is distinguished on the facts because of the state case, contractor has not approached the grievance committee. And this court delegated the contractor to invoke the jurisdiction of the for maintaining his grievance. Note that the division bench in the case of Anup State observed that based on the rate quoted at 1141 per kilometer, the court does not result in reassessment of rate. However, the present case is not a case which involved the exercise of reassessment. The original rate quoted by the contractor was converted to per metric ton. The same thing, well, in this case also. Per metric ton by FCI.
No, we are not on the rate.
My lord?
We are not on the rate. Dispute is not on the rate. Dispute is only on the distance factor.
Distance, my lord. Distance is, my lord, exactly same, my lord.
No,
And
there is a difference in your projection and the projection made by the FCI. Are we in a position to either accept Mr. Singh or Mr.
My lord, I'm coming to that. I'm coming. My lord, your lordship will see, this was the, my lord, as per the tender, the road was beginning from Salcha plus page 1989. Page 89.
89.
Item number 3, my lord. Page 89. from beginning to Kolkata siding to Weybridge is 14.5 kilometers. Then Bhadrapur Ghat Tilted diversion point to 62.5 and Koyapur Highway bypass point 66.2. Total is 3.2. And on this basis, my lord, all the restrictions were earlier considered.
This is what report?
My lord, this is the report of the committee.
What committee? Grievance committee? Or what?
My lord,
Which committee?
no, this committee, my lord, which again see the road, my lord, how far distance is there on the request of the petitioner as well as other parties. And on this basis, my lord, the two other representations are also considered. Now, my lord, they have found some different rate which is not quoted in the tender. How that can be, my lord, considered here?
No, so far as rate is concerned, we will not deviate from the rate.
No, rate
With-
is, rate is
don't-
no question.
But so far as the distance is concerned, if the contract stipulated that it was 292, but you said that no, distance is 343, and if it is found it's 343.2, you should pay 343.2.
Yes, well, they have to pay, my lord. They cannot say, my lord, now. My lord, here,
Now, there is another committee report dated 11/8/2023. We have annexed at page 194.
194.
194. In that committee report, we have categorically stated that the earlier committee has not considered the shortest possible route mile and taken the longer route mile. The shortest possible route is 290 kilometers.
Yes.
Yes, ma'am. Page 194, my lord.
Please read.
Annexure B in my affidavit in.
Yes, we have found.
My lord, before that, I will take your lordship to the earlier judgment, my lord, rendered by the Honorable Division Bench, my lord. And I will like to point out certain clauses of the NIT, my lord. If my lord may take up the writ petition, may come at page 49, my lord.
If it takes time, we will have some, this on a hearing date.
Yes.
my lord,
If it takes time, then we'll have this
It
on a
will-
hearing date. There are some, many matters pending. We thought that it would be covered by the division bench.
actually covered, my lord, they are disputing, my lord. They come at different route, my lord, altogether, which is, okay, my lord.
Yes, tell us when, Thursday next,
On 12, yes.
Thursday next. Okay. But you might have preferred an SLP. If there is no stay, why shouldn't we follow the
No, writ appeal was
division
in my
bench?
favor, my lord.
Writ appeal is in our favor.
In my favor. Writ appeal that we have prepared, my lord, challenging the single bench order. Where
That has been allowed.
that has been allowed, my lord.
Now, who has gone to
That has been the
SLP?
single bench order has been set aside.
Who has gone to SLP? You said somebody has filed SLP.
In other cases, which my learned senior friend is referring that TP Chaudhary holding, where we have lost, my lord, that we have preferred rather.
That we are considering. If there's a writ appellate judgment, it will be binding upon us.
In the other case, my
The
but
DB
here
only
the
they have
fact,
No,
paid the amount, my lord.
depending on the same committee report.
Yes,
but now we have come with another committee report that in other was that was okay, but in this case, my lord, the shortest possible route was 290 kilometers, my lord. The earlier
Okay, we'll consider.
committee report has not taken into consideration the shortest possible route, my
Oh. It is submitted that that pleadings have been exchanged and the matter can be disposed of at the admission stage. Full stop, parent. Please for admission hearing on 12th. 12th will be there, Mr. Sayala?
my lord.
Obliged.
It's just not certificate dispose of. In fact, it proposal is all the
What is the matter, Mr. Boro?
This is for non-payment of the contractual bills amounting to rupees 32,71,944. I have
already
completed the
FS has been prepared, Lordship.
part payment has already been made. Part payment has already been made, madam. This is the remaining amount.
What is your take?
My instructed Lordship already proposal for this amount has been prepared, Lordship. So it will go to the final. Okay.
We'll not close this. If there tomorrow there is inaction, he'll again have to come to the court. Sri P. Upadhyay,
N.
Learned,
Upadhyay.
sorry, N. Upadhyay, Learned, Standing Council. This will become under irrigation, irrigation department submits that the proposal has been issued by the department to the finance department regarding the outstanding dues of the petitioner. What's the para? Considering the above, the matter is deferred to be listed after the long vacations. On the next date, Sri Upadhyay, the Learned Standing Council, as well as Sri Boro, the Learned Council for the petitioner, shall apprise the court of the further progress achieved.
All right.
I would have last time has posed a specific question whether decision making process of forfeiting the EMD. And my instruction is that till now no EMD has been forfeited, my lord. Only we have cancelled the contract and thereafter they have approached this honorable court, my lord. So the matter, since the matter is of circuitous, we have not taken any action, my lord. Now, my lord.
EMD has not been forfeited.
No, not been forfeited.
Yes, Mr. Council, EMD has not been forfeited.
My lord, we were verbally informed that EMD has been forfeited.
Verbally informed.
And
No,
my
it has
lord, it's
not been
been
forfeited.
more than a year and the EMD amount has not been refunded back to us.
Refund the amount.
May I complete the hearing?
No, we are not going into the merits. Refund the amount. There, we had heard this matter some.
No, my lord, GST consideration was that whether GST is required or not, my lord. My humble submission is that the GST is required.
No, we are not, see, the work orders were issued way back in the year 2023, I think. So there's nothing to be decided here. It's only a refund of the EMD.
No, my lord, if they have not, as per the clause, my lord, if they doesn't submit the EMD, my lord, as per clause 2, my lord. Take your document for 2.
Yes.
At page 83, my lord.
83.
8.
2 Roman 2, my lord.
Two,
Down below, my lord, clause 2, Roman 2, my lord. It comes under the heading of instructions to bidders and terms and conditions governing bid condition. Parties will be allowed,
yes.
parties will be allowed to participate in the auction subject to the submission of stock declaration clarification in the website as per GOI dated 12/6/2023 and policy dated 26/2023. Scan copy of the necessary undertaking along with a copy of valid FSI license, a copy of GST state tax registration certificate issued from the state concerned, and the latest stock declaration statement declared on the previous Friday as per the appendix 3 and at appendix 4, that is mandatory, should be submitted to the concerned divisional office through email at the time of submission of the cost for verification of the same at the divisional office level before the issue of the release order, failing which the bid stands cancelled and the EMD shall be forfeited. The impanelment of the interest bidder is ongoing and continuous process, and those bidders who are interested to get themselves impaneled may contact the helpdesk provided by the AND junction on toll-free numbers. Then, my lord, again,
Yes.
on the other day, my learned friend was referring A1 and A5. My lord, this is the clause for getting themselves impanelment to the M junction, my lord. M junction is the portal, my lord, which the FCI has engaged them. They are the independent thing, my lord. Where they have to impanel.
Which page?
Page, my lord, 81. Terms and conditions for impanelment of technically qualified bulk consumer. So this is the terms and conditions for getting themselves impaneled in the M junction so that they can bid our tender, my lord.
What is this junction?
M junction is, my lord, portal, my lord, where the FCI has engaged a independent agency to conduct this e-tender.
My lord, it's
Let's complete.
platform. It's just a platform, online platform, and in that platform, GST uploading the GST certificate is not mandatory. There are few columns wherein star has been marked, which is mandatory.
Okay, we'll come back to yes, ma'am. This 81 is for only for empanelment.
Only for the empanelment. And further, my lord, the letter which was pointed out on the last occasion, that is page 353, my lord.
Page
353, my lord, of the affidavit in reply by the petition.
Yes.
The petitioner is writing letter to the M junction, my lord. Say Mr. M junction. We are submitting the document of new registration of FCI M junction. Please find the attachment attached below. They have attached some certain documents. Thereafter, the M junction has stated that please send this document. So nothing to do with the FCI, my lord, Food Corporation of India.
My lord,
for getting themselves empaneled in M junction, they were asking for certain documents. We have no say there.
You are contending that being empanelment, being empaneled is a different aspect, and the Bidding for the work is a different aspect.
Yes, ma'am.
One may be empaneled and one may still not bid.
Yes, it's a continuous process. They will get themselves empaneled. They may participate in
That is
another
it.
tender.
No, is it required that all the empaneled members have to participate in a bidding process?
They will first of all impanel in the junction. Thereafter, they will participate and they will
That
follow
is-
all the clauses which have been.
That is what we are asking. See, once you get yourself in the platform, junction, e-platform, is it required that being in the e-platform, you are essentially or necessarily required to participate in a process, or you may not?
May not also.
May not.
May not. He may not participate in this. He may participate in the
Some
next-
other.
Yes, on the next
Okay,
next tender.
Simply by empanelment, it doesn't mean that he will be considered unless he expresses willingness.
Unless he participate in the bid.
Participate, okay. Now, for participation in the bid, you say GST is necessary.
GST is necessary as per clause 6.
For empanelment, GST may not be necessary.
May not be necessary.
Okay.
So, my lord, I want to refer earlier tender, my lord, that is 10/3/2023, where GST of a particular state was not necessary.
Just a minute. Page?
Okay, I have brought for NIT of earlier tender, man. 10/3/2023.
9?
10/3/2023. Thereafter,
10/3.
10/3. Thereafter, the GST was required of a particular state where the bidder will participate. The clause 5 may be seen.
Yes.
May I read it? And number 1 of the mandatory prerequisites for the impanelment of flour mills, traders, impanel bulk buyers, manufacturers of the wheat product to be continued as unique identifying factor. Against one PAN number, only one participation will be allowed in one bid in a region. In each weekly auction, irrespective of the number of firms registered or multiple GST under the same PAN, or the number of branch offices in different states, subject to the maximum quantity that a buyer can bid 3,000 MT. Earlier it was 3,000 MT and can participate anywhere. Now, if we read now the present clause of the present NIT, my lord, at page 79. Like, by illustrating one example, my lord, he tried to exchange
79.
page 79, clause 6,
Yes.
the bold one. Against one PAN number,
Yes.
only one participation will be allowed in one bid in a state, union territory, in each weekly auction, irrespective of number of firms registered or multiple GST trade tax registration under the same PAN. Bidding would be allowed in a state against the GST trade tax registration registered in that state duty only. The maximum quantity that a buyer can bid is now 100 MT against one PAN and GST trade tax registration of the state duty concerned. For example, if a bidder is having the GST trade tax registration from the state of Haryana, he can bid for the stock from Haryana and not for the stocks offered from any other state region of the FCI. However, there is no bar in participating the bid by that bidder from the other states if he is having different GST trade tax registration in such other state. My lord, this however thing is not accepted, my lord. It's tried to explain it that if he is multiple GST in different states, he can participate, my lord, provided he is also having the state GST registration of Assam, my lord. Then, my lord, I would refer to one Annexure C of my affidavit in opposition.
Okay, we'll come back at 2 o'clock.
If kindly come to my lord, please, just 2 points are there.
262. Yes.
My lord, third line. As per the terms and conditions of the MTF, the intended buyer has to register himself in the M Junction Services Limited, and in the instant case, all the petitioners have impaneled themselves under the West Bengal in M Junction portal. It was observed from the active bidders list circulated by M Junction, all the petitioners have GST registration of West Bengal details of which has the details has been given. So for participation, they have in the bid, they have impaneled in the M Junction of West Bengal region, but they have applied here. I think contention is their contrary. They say that as GST registration is not required, but here in West Bengal they have registered under the GST method. But it is not known why they have not participated there in West Bengal. Further, my lord, page 263. Petitioner is also claiming that as per the section 23 of the GST, registration is not required, my lord.
Yes.
There is a notification of the central government dated 17/7/2022.
Page?
Page 263, my lord. Next page. We have made a statement, my lord.
263, yes.
It is pertinent to mention here that the MTF, the terms and conditions at clause 3 to stipulate that a party should have a copy of GST trade tax registration certificate issued from the state concerned. The provision of GST trade tax registration has been made compulsory as GST is applicable in respect of packet and label commodity cereals like rice, wheat, and flour, atta, etc. In this regard, reference is drawn towards the Ministry of Finance Department of Revenue by notification dated 7/7/2022 under the subject FAQ on GST applicability on pre-packaged and label goods has to the following. We have also annexed it, my lord, it is as Annexure C at page 284. The only one is relevant. What changes has been made with respect to the package and label commodity with effect from 18 July 2022? Prior to 18 July 2022, GST applied on specified goods when they were put in a unique container and were bearing a registered brand name or were bearing brand name in respect of which an actionable claim or enforceable right in a court of law is available. With effect from the 18th July 2022, this provision undergoes a changes and GST has been made applicable on supply of such pre-packaged and label commodities abstracting the provisions of Legal Metrology Act as detailed in a subsequent question. For example, items like pulses, cereals like rice, wheat, and flour, atta, etc. earlier attracted GST at the rate of 5% when branded and packed in a unique container. With effect from the 18/7/2022, these items would attract GST when pre-packed and labeled. Additionally, certain other items such as curd, lassi, puff, rice, etc., when pre-packaged and labeled, would attract GST at the 5% with effect from 18 July 2022. Essentially, this is a change in the modalities of imposition of GST on branded specified goods to pre-packaged and labeled. So, my lord, the GST is required, my lord. Then, my lord, another point. Kindly, my lord, come to page 381. 381. They say that ITC has been allowed. In fact, there was a wrong reply was done to the petitioner. Thereafter, we have clarified that ITC were registered under the Assam GST, my lord. That paragraph 12 start from 380. The relevant part is here, my lord. From the middle part. However, an error occurred in the response to the RTI application number so dated 28/7/2023, where the GST number of Bihar was mistakenly included instead of Assam GST number. This was an unintentional error. A revised RTI reply has been sent to the applicant on 27/6/2024 with copies of ATM so. Additionally, a so-called notice has also been issued to the concerned dealing assistant for the lapse. So, my lord, we have given the chart where the ITC were registered under the Assam GST, my lord. So far as the Jharkhand is concerned, my lord, two of the they are saying that the two of the bidders, in our reply, we have given that two bidders were not having the GST number at the Jharkhand. That too, they have taken up, my lord, that is the of eastern region, my lord. Where here we are northeast region. We are not concerned about that, but definitely the authority will take into action. But because of that person has been given, they cannot take the plea. Here, what mistake there it has been done. But admittedly, GST is required, my lord. They have impaneled at West Bengal.
My lord, NIT is applicable pan-India.
Yes, to that mistake we are saying that that has been caught. So, my lord, further, he is saying that the GST is not applicable. He has not challenged that clause, my clause. Our
Which clause
contention is
6?
that as per clause 6, GST is required. So that is my humble service.
Okay. Yes.
Yes, sir. My lord, coming to the submission, that the email, which was the page number 353, my lord, email dated 18 June 2023.
Email dated
18 June 2023, page number 353.
18 June 23.
2023, page 353,
Yes.
annexure 4, my lord.
Yes.
My lord, in this, the FCI has just submitted that the FCI has no inclusion in regard to the response given by the help desk of the M junction. My lord, in the email ID itself, it is stated that the FCI help desk. So FCI has it is the email issued by the FCI itself. And apart from that, my lord, the M junction was appointed by the Food Corporation of India. So they cannot take the plea that this email we do not have any kind of knowledge of. Further, my lord, arbitrariness and discrimination definitely has taken place with me, because two of the firms who do not have GST registration, they have been allotted. And now we do not have GST registration and we are being denied for this.
Now, how do you deal with clause 6
My lord, clause 6,
at page 79?
yes, my lord. My lord, this clause 6 itself is only in regard to the PAN number. And the eligibility, the main portion which is in regard to the eligibility, that is clause page number 81, clause A1 and A5.
That is for empanelment.
Yes, my lord.
That is for empanelment and in M junction.
Yes, my lord. My lord, at the same time, for the eligibility criteria, A1 and A5, it is stating that you are not required. In order for you to be eligible, you are not required.
Eligible for the empanelment.
Yes, my lord.
This, we are not on the empanelment factor. We are on the factor of bidder.
Yes, my lord.
That is why you have repeatedly asked whether empanelment will necessarily mean that you have to bid. You may not bid.
Yes.
You can go up to the platform. Doesn't mean that you're sitting on the platform, you are in a position to be considered. Then also you have to fulfill certain eligibility criteria, namely 6. For being empaneled, you need not be necessarily registered under the GST. But to bid, you have to be. And in that state. And you can still bid in 2 more states. If you have provided you have the GST of the particular states.
My lord, even if assuming, not admitting, just assuming for the sake that this GST was, according to clause 6, it was required, then we already priorly intimated them that we do not have GST registration. Please provide us that we are eligible to participate and bid. And subsequently, my lord, we have sent corresponding various emails, and in which the Food Corporation of India has replied that you provide us so and so documents. And further, my lord, according to clause page 86,
No,
clause 9.
those emails were in respect of your empanelment. That CA certificate, books of accounts.
Yes, my lord.
were in respect of the empanelment, not for bidding.
My lord, it
Those
was,
were issued by the M junction.
yes, my lord. It was, then, my lord, even if assuming, my lord, in page number 86, communication of acceptance, the process of communication of acceptance offer has been mentioned.
Hmm. Yes.
The contract, if any, which may eventuate from the e-auction shall be governed by the conditions as mentioned in the terms and condition of the e-auction,
Yes.
its appendices, annexures, notices, inviting bids and acceptance letter.
Yes.
Acceptance letter is supposed to be issued after based on the terms and conditions. So that means the terms and condition has been scrutinized. My eligibility and bid has been scrutinized.
Acceptance of what? Not of the acceptance, not of the bid. Acceptance of the offer, contract,
Acceptance of the
offer.
yes, sir.
You see what is the language? The contract, if any, which may eventuate from the e-auction shall be governed by the conditions as so and so and by acceptance letter.
Yes, my lord. Further, after
Your bid has to be accepted first.
my lord, my bid was accepted. Acceptance offer was issued to me.
Taking the bid into consideration is not acceptance. Acceptance means the binding contract.
My lord, in the further it is stated in the third clause 9, third paragraph, the acceptance of bid by the general manager or an officer authorized by him on his behalf shall constitute the
contract. It is the binding contract.
It's a binding contract.
Yes.
And my lord, acceptance offer was issued by the general manager to us. It becomes a binding contract, and government.
Let us see the acceptance again. Let us see the acceptance.
Acceptance offer. Page 96. And my lord, last date of hearing.
Yes, what is this? 96.
My lord, it is the acceptance offer which has been issued by the Food Corporation of India. My lord, page number 96 to 104 of all the petitions.
Mr. Singh, what is this?
Yes, I will we have clarified in our paragraph 8, ma'am, of affidavit in opposition for the computer generated and fixed by the ANTEC. But has to be gone further, my lord. My lord, I will rely on my paragraph 8 at page.
Okay, we'll come back to you. We'll be ready with this. We'll come back to you. Be ready with this
Yes.
answer. Yes. What else?
Yes, my lord. My lord, apart from that, my lord. My lord, before the issuance of the acceptance offer, the only determination of the authentication of the document which was priorly submitted to the M junction. It is not the case where the acceptance offer is auto-generated. It is not the case, the impanelment thing, my lord, the bidding, that impanelment has to be done only after the scrutinization that the documents which are submitted in the M junction are authenticated or not, whether it is authenticated document or not, or a false document. It is not in regard to whether these documents have been submitted or not, whether GST certificate has been submitted or not. That is done at the level of M junction, at the time, at the initial stage, my lord, whether all the documents have been successfully submitted or not. And subsequently, my lord, the EMD amount and everything, the acceptance offer is issued. It is not, acceptance offer cannot be auto-generated to everybody. Government is doing entering into contract with an open eye, and they have to adhere with the obligations. Further, my lord, no show cause notice was given to us, no opportunity of being heard. There was a breach of principle of national justice. Further, my lord, rejection email 20 July 2023 was issued by the additional general manager, AGM, commercial. It was not the general manager. According to clause 9 of the NIT, it was open for the general manager to accept or reject the bid acceptance offer.
What is the difference between GM and AGM, additional deputy general manager, so far as discharge of functions of this kind is concerned?
My lord, both are different designation. In NIT, only general manager is mentioned. Additional general manager commercial is not mentioned, my lord.
Let us see the email.
Clause 9.
Email.
Email. Page 70, my lord.
70.
70.
Yes. Yes.
Further, my lord, the FCI was supposed to submit today the communication and the instruction given by the FCI headquarters in regard to forfeiture of the AMD amount and revocation of the acceptance.
It is yet to be for, decision is yet to be taken for forfeiture.
My lord, it's been 1 year. The amount has, the communication has also not been sought. 1 year they have not verbally, they have appraised, they have rejected my acceptance offer.
Where is that clause saying that
General
the
manager.
general manager?
Clause 9 of the NIT, my lord.
Page.
Page 86.
Right.
Whether the officer was authorized or not, that is also not known, my.
Okay. That's all?
My lord, now coming to the legal precedents in regard to government tender, my lord, there is the Honorable Apex Court judgment in the case of MP Sugar Mill versus State of UP.
Citation?
Citation, my lord, 1975, 1 SCC, Volume 1, SCC 737. My lord, it is in regard to doctrine of promissory estoppel that once an offer has been accepted, my lord.
Which one? Which case are you referring? LD Sugar?
Yes, my lord.
What is the name of the case?
MP Sugar Mills was State of UP. Further, my lord.
Paragraph?
My lord, kindly come to para 27 of the writ petition.
No, yeah, paragraph of the citation.
Citation.
In Sugar Mill, MP Sugar Mill's case.
Yes.
Which paragraph? But how is the doctrine of promissory estoppel applicable here?
My lord, acceptance, since the acceptance offer is issued, it becomes a binding contract between.
That is not promissory estoppel.
Yes, my
You
lord.
can say that it's a breach of contract. Where is the question of promissory estoppel?
My lord, they promised me to since the acceptance
That
offer
is a
was
breach of
issued.
contract. It's not a promise. You can be on a much better footing if you argue. There's a binding contract, you
Then,
can
my lord,
say.
breach of contract.
Where is the question
my
of
lord,
promissory
I will come
estoppel?
to breach of contract as well.
Estoppel is by some words you change your position, then you cannot revert. That is the promissory estoppel. Doctrine of promissory estoppel is not applicable here.
My lord, acceptance, another precedent laid down by the Apex Court, acceptance of a bid amounts to a concluded contract. My lord, page number 27, I have quoted the relevant paragraph. Honorable Apex Court, in the case of Harsh Shankar and others versus the DY Excise and Taxation Commercial. My lord, in page number 28, para 17, from the middle, my lord, the announcement of conditions governing the auction were in the nature of an invitation to an offer to those who were interested in
This
the.
earlier citation is not MP Sugar.
My lord, earlier citation is also applicable, my lord. In
No,
this
he's given the same citation, 75-1 SCC 737.
737. It is in regard to my lord Harsh Shankar.
You said MP Sugar. What is the citation of MP Sugar?
1975, volume 1, SCC 737.
How can it be same two cases in the same page?
MP Sugar Mill. My lord, civil appeal number.
Not reported. Not reported.
My lord, it is a reportable judgment. My lord, another citation has been mentioned, 1979, 2 SCC 409.
(1979) 2 SCC
409.
That is MP Sugar.
MP Sugar Mill, para 36.
And 1975 1 SCC 737 is Shankar, Har Shankar.
1975, 1 SCC 737, Harsh Shankar. My lord, in this Harsh Shankar case, Honorable Apex Court observed that tender conditions are an invitation to offer. The bids given by the response were offers. The acceptance of such bids were acceptance to the offers, and on such acceptance, the contract between the bidders and the government become concluded and binding agreement.
Yes.
In this, my lord, the Honorable Court further observed that the announcement of the conditions governing the auction were in the nature of an invitation to an offer to those who were interested in the sale of the liquor. The bids given in the auction were offers made by the prospective vendor to the government. The government acceptance of those bids was the acceptance of willing offers made to it. On such acceptance, the contract between the bidders and the government became concluded and the bidding agreement came into existence between them. Further, my lord, the court also, in the very same paragraph, has also observed that those who contract with an open eye must accept the burdens of the contract along with its benefit. And in the same judgment, para 23, my lord.
Yes.
It is stated, the short answer to this contention is that the bids given by the appellant constitute offers, and upon their acceptance by the government, a binding agreement come into existence between the parties. The condition of auctions become the terms of the contract, and it is on those terms that license are granted to the successful bidders. Further, my lord, in the case of proactive in and out advertisement private limited, page number 31 of the writ petition. It's a Bombay High Court judgment, my lord, wherein the Honorable Bombay High Court is stating in paragraph number 20, this court is sensitive to the fact about the limitations in the matter of review administrative decision is extraordinary jurisdiction, but the review decision in contractual matter is very permissible. Now, my lord, coming to doctrine of promissory estoppel, as submitted priorly, my lord, in the case of MP Sugar Mills, page number 33, 34, and 35 of the writ petition.
Yes.
the law may therefore now be taken to be settled as a result of this decision that where the government makes a promise, knowing or intending that it would be acted upon by the promisee, and in fact the promise acting in reliance on it alters his position, the government would be held bound by the promise, and the promise would be enforceable against the government. At the issue,
How have you altered your position? What is the change in your legal position?
they are changing the position that
How have you changed your position based on the promise? That is a condition precedent to invoke the doctrine of promissory estoppel.
yes,
That
sir.
you have changed your position.
Yes, sir.
How have you changed your
My
position?
lord, since I was granted acceptance offer, I made further arrangement. I contacted my other customers that 100.
Where is the agreement?
My lord, acceptance offer itself become an agreement in accordance to the Harsh Shankar judgment.
There has to be an agreement.
My lord,
After the agreement, you can you stay without a work order, can you go ahead with the work?
my lord, acceptance offer becomes a binding contract between the
Thereafter, nothing is required.
a release order is left, my lord. Only the release order.
An agreement needs to be signed, a work order needs to be issued.
My lord, after the acceptance offer is issued, only the release order is supposed to be left for releasing. There is no separate agreement which are required to be executed according to the same, my lord, according to clause. No separate agreement is required to be executed, my lord. Only acceptance offer according to the NIT, my lord. My lord was my lord, in clause 9, page number 86 of the NIT. Last paragraph. 86, clause 9.
Yes.
The acceptance of bid by the general manager or an officer authorized by him on his behalf shall constitute the contract between the bidders and the Food Corporation of India. No separate agreement is required to be executed after the issuance of the acceptance letter. Acceptance letter itself constitutes to a binding contract. Further, my lord, another precedent laid by the Honorable Apex Court, post government should abide by the terms. The discretion of the government is not unlimited. That is to say that the government cannot give or withhold largesse in its arbitrary discretion or at its sweet will. The same has been laid down by the Honorable Apex Court, page number 45 of the writ petition, my lord. My lord, page number 48. The Honorable Apex Court has observed.
Yes.
The decision of the government has been held to be not unlimited, in that the government cannot give or withhold largesse in its arbitrary or in its arbitrary discretion or at its sweet will. My lord, in my case, 2 of them were given release order, 2 of them were successful bidder, and I was denied because I do not have GST registration. They are acting at its sweet will. Further, my lord, in page number 15, the very same judgment.
Page
50. But the court, my lord, second line starting, but the court speaking to the learned Chief Justice responded that the government is not like a private individual who can pick and choose the person with whom it will deal. But the government is still a government when it enters into contract. When it is administering largesse, and it cannot, without adequate reason, exclude any person from dealing with it or take away largesse arbitrarily.
Yes.
The activities of the government have a public element, and therefore there should be a fairness and equality. State need not enter into any contract with anyone, but if it does, it must do so fairly without discrimination and without unfair procedure. Further, my lord, in page number 52, Honorable Apex Court in the case of Air India Limited versus Coaching, page number 51, my lord. Air India Limited versus Coaching Institute, Airport Limited and others.
Yes.
It's a judgment of 31st January 2000. The Honorable Apex Court has observed, but the state is
Why have you
corporation
quoted all the judgments in their pleadings? Not
for the better
necessary.
convenience of the Honorable Court.
Not necessary. You're not supposed to. It's not, pleadings should not have judgments like this. Pleadings should only have the facts and the law involved, nothing more than that. Where are you filling up the pages? You can just refer to judgments. Air India. What has been stated in Air India?
It is stated that, but the state is corporation, instrumentalities and agencies are bound to adhere to the norms and standard and procedure laid down by them and cannot depart from them arbitrarily. Though that the decision is not amendable to the judicial review, the court can examine the decision-making process and interfere if it is found vitiated and malified unreasonableness and arbitrariness. Further, even in the same para, even when some defect is found in the decision-making process, the court must exercise its discretionary power under Article 226 with great caution and should exercise it only in furtherance to public interest and.
Okay.
Further, my lord, principle of natural justice and Article 14, my lord.
Okay.
My lord, Honorable Apex Court in the case of Mohinder Singh Gill versus the Chief Election Commissioner Delhi have held that when a civil right is adversely affected, the doctrine of odi ultram partem must be complied. No show cause, no opportunity of being questioned.
That you have already submitted. Mr. Singh,
My lord, with regard to the acceptance offer, ma'am.
Yes, yes.
Yes, my lord, my paragraph 8, my lord, page 50.
Page
206.
260.
26. Part of my affidavit in opposition.
Yes.
paragraph 8.
Yes, paragraph 8.
Paragraph 8.
Yes.
All paragraph, may I read it?
Yes, yes.
In this regard, it is pertinent to mention here that the system generator acceptance of offer is immediately sent by the application after the completion of bidding, with the understanding that the parties participated are fully aware of the terms and conditions, possesses required valid documents to be submitted to the concerned divisional office through email at the time of submission of cost, for verification of same at the divisional office level before issue of release order, failing which their bid stands cancelled, PMD shall be forfeited. Now, I will take your lordship to the instructions to the bidders, my lord, at page 83.
But this was not generated by M junction, it was issued by your AGM.
No, my lord, I will come.
Page?
Page, my lord, 82.
Yes.
Page 82 down below, instructions to bidders and terms and conditions governing key of auction. Number 1, definition.
Yes.
Now, the relevant clause, my lord, at page 83. Roman 4, M junction shall
Yes.
mean M junction services limited, which has been appointed by FCI for conducting key auction on its behalf.
Yes.
5. The term general manager shall mean the general manager of Food Corporation of India, under whose administrative jurisdiction the Food Corporation of India depots or godowns to which the contract relates fall. The term general manager shall also include the deputy general manager, area manager. Now, this area manager is now is equivalent to the post of a assistant general manager, and any other officer authorized by the time being to execute the contract on behalf of the Food Corporation. And the general manager will not execute all various contracts.
That otherwise also you have not accepted. As rules of executive business allows.
Yes,
If
ma'am.
secretary
We
means
have
a
a
joint
standing,
secretary.
we have a standing circular, my lord. If necessary, I can produce. Now, the down below, my lord, the 2, Roman 2.
Yes.
My humble submission is that the has not completed, my lord. The mere issuance of acceptance offer does not conclude the
That you have
contract.
already stated, okay.
My lord, down below, what is to be done thereafter, after the acceptance offer is issued, my lord? In Roman 2, my lord.
Yes.
I will read it from middle one. I have earlier read it once. And that the appendix 4 mandatory should be submitted to the concerned divisional office through email at the time of submission of the cost, for verification of the same at the divisional office level before the issue of release order. Failing which their bid stands cancelled and EMD shall be forfeit. So after the acceptance offer, there will be a verification by the divisional officer where this bid will be released. After verification, cost deposition, thereafter the release order will be. So this verification part is there. If the parties are found that they are not eligible or their documents are not okay, so my lord, my humble submission is that the contract has not concluded mere issuance of this acceptance offer, which is issued by the MJUN on behalf of the FCI.
Lord, in this first the verification.
Okay, this cannot be like this. We have heard all the parties. There cannot be reply of reply. We're closing this.
Yes,
my lord, just one submission, the verification clause which is submitted. My lord, the verification is done only in regard to whether the document submitted is authenticated or not that whether all the documents are submitted or whether the candidate is eligible or not. It is supposed to be done.
Now, how do you overcome the second sentence, third line? A scan copy of the necessary undertaking along with a copy of so and so, a copy of the GST. How do you overcome this? These are the documents which should be verified.
Yes, sir. And since it was to be verified, we were given acceptance. My lord, my case is that it becomes a binding contract.
Yeah, we have heard three. The
And
Rathi, learned
discrimination,
counsel,
my lord. Other two firms were given. Release order.
for the petitioners also heard the BK Singh, learned standing counsel FCI. The hearing is concluded, judgment is reserved. Okay. Yes. কিন্তু মাৰি দিব লাগিব এটা আগৰখনৰ ফুল লগত
Obligement.
Oh. এইখন কি হ'ব?
Paid to the right. Very small matter, but it can be disposed of. The second round of litigation. Initially, what happened, my lord? Against the particular scheme, they applied for it. But my lord, their prior, it was also recommended by the GM. That was rejected by the.
Applied for what? Applied for?
Applied for, my lord, subsidy scheme.
Subsidy
That
of-
is CCIS. CCIS.
Subsidy for as regards what?
It's a T state, my lord, for.
You are a T state.
T state, my lord, for putting up.
So central
Machineries, my
capital
lord,
investment
and
Central?
capital investment.
Or capital investment subsidy.
Yes, sir.
No,
This
so
scheme is
also
at page
I'll
27.
just clarify because it can be disposed of. So what has happened is like when you claim for, this subsidy, so that plant and machineries, which will be taken into account are those plant and machineries which were purchased after the there is a mandatory pre-registration under this scheme. So while rejecting their claim, what has happened in the second round of litigation, for rejecting their claim, they have taken the date of pre-registration as a different date.
Okay.
So what has happened then, while calculating it, they have taken certain machineries to be purchased
Prior to the
prior to the registration. So now when the documents were properly evaluated, then we have found out that like actually the registration date would have been something else. So like all these machineries, they have purchased after the registration. So I have filed an affidavit stating that. So now,
Main issue
that
is that
stand is clear. Now this can be sent it
the
to
rest of the
consideration,
they have partly paid, and the rest of the amount, my lord, they are entitled.
Where is your affidavit?
affidavits, let's say, we have filed on
Yeah.
filed on 24/7/2020.
That does it not.
Yes, sir. Yes, sir.
Okay.
That does it not. No. That does it not
No.
net fee.
This is filed by
Yes.
Tarun Kumar Katak.
Page 62 onwards.
$62.
After the first round of litigation, they have partly paid. And after filing the second petition, my lord, petition, that were entitled.
Paragraph 10, let's say, I have explained the whole.
Yes, that is there. At page 68. But I can read it from page 67.
এসিটা বন্ধ করে দেন, ঠান্ডা আছে বহুত। এসিটা বন্ধ করে দেন। দেখা heard.
Only one thing, my
Yes.
the balance amount, my lord, they are entitled. The one question is, my lord, that the amount they have filed application 2008. Thereafter, my lord, for litigation that my lord is 16 years. In other cases, my lord, transport subsidy cases, interest has been awarded.
No, interest issue is lots of not there.
Then your
Interest
it
issue
should be kept open, my lord.
interest issue is already pending in the.
Supreme Court.
It
My lord,
hasn't been
in these cases, my lord,
it hasn't been.
transport subsidy because of inordinate delay, here is also.
That
no-
has, that
no
issue
fault
is
of
pending
mine,
before this.
Inordinate delay, then.
But
can
that
be kept open.
interest issue is pending because in few of the cases which
Yeah,
we,
it is pending
we
before.
have
the-
held, we have that it will be governed by the, so far we'll make an
Yes,
observation.
my lord, yes.
Whatever will be
Yes,
decided by the, if the,
Yes,
Then
my
they can file a
It-
press
it
press
should be kept
application.
open, my lord. That's it. Kept open. 16 years.
heard. MSN Saikya, Learned Counsel for the petitioner. Also heard Sri A. Kulita, Learned Standing Counsel, Industries and Commerce Department. Your name? A?
Biani.
Okay, Biani, for net fee. Response number 4. Lehisa? Considering the facts and circumstances and as agreed to by the learned counsel for the parties, the writ petition is taken up for disposal at the admission stage. Para, please have your seat. As per the facts projected, the petitioner is a registered company. Full stop. The issue involved is with regard to the Central Capital Investment Subsidy Scheme of 2007 under the Northeast Industrial Investment Procurement Policy. What PP was, what was the full form?
Central.
No,
it is
no.
in the Central Capital Investment.
Northeast Industrial NEIIP
Yes, Northeastern Industrial Investment.
Investment. What policy?
What policy? I go to the policy. I'll go to the policy. It is, my lord. Northeast Industrial and Investment Promotion Policy.
Promotion Policy, 2007.
2007.
Full stop. It is the case of the petitioner that pursuant to a notification dated 27/7/2007, which was issued in accordance with the said scheme, the petitioner had applied in the standard format for availing such subsidy. Full stop. The proposal of the petitioner was forwarded and was put before the state level committee for approval. Full stop. The meeting had, however, approved an amount of rupees 1,14,41,547. 1,14,41,547 instead of 1,48,90,000. Full stop. The balance claim was rejected in a subsequent meeting held on 11/11/2021. Full stop. The petitioner had earlier approached this court by filing WPC 2228, 2228 of 2014, in which this court had passed an order dated 7/1/2014 directing release of the admissible 30% of the CCIS amount, full stop. However, the respondents had only released part payment of the recommended amount, full stop. Accordingly, the present petition has been filed with a prayer for release of the recommended amount, which was reduced, full stop. Para. And Ms. Saikia, the learned counsel for the petitioner, has submitted that the deduction was wrongfully done and the entitlement of the petitioner has not been given, full stop. It is also submitted that the crucial date for making the calculation is 9/4/2008. 9/4/2008.
Yes,
9/4/2008. Full stop. However, a subsequent date was taken into consideration for which many of the plants and machineries were not taken into account for calculating the eligibility. Calculating the amount which would be entitled to by the petitioner under the aforesaid scheme. Para. 3. Colita de Lanet's standing counsel, by referring to the affidavit in opposition filed on 24/7/2024, has however fairly submitted that in the initial exercise, due to some inadvertent error, few of the plants and machineries were kept outside the purview of assessment, as those were deemed to have been installed after the date, that is 9/4/2008. No, it was deemed then. However, on a re-verification, it was found that such machineries were in fact installed prior to the crucial date. Full stop.
Your Lordship, what has happened is that not prior to the crucial date, that after the crucial.
Oh, sorry.
After the.
Last word কি হলো? After the date, crucial date, that is 9/4/2000.
Yeah, that is the registration date.
Date, which is the date of the registration under the
Registration for the scheme.
under the NEIIP.
Yes.
Full stop. By drawing the attention of this court to the averments made in paragraph 10 of the affidavit in opposition and the enclosures made therein, the learned standing counsel has submitted that the statement of plants and machineries purchased by the petitioner, along with the registration certificate and clarificatory letter, have also been enclosed. Full stop. Para. You have any role, madam? You have any role in this case? Okay. Ms. So-and-so, learned counsel for the net fee, submits that the lease is between the department and the petitioner, and net fee only plays the nodal role of being the disbursing agency. Full stop. Para. After hearing the parties, this court is of the opinion that in view of the clarification given by the department in its affidavit filed an affidavit referred above, comma, the writ petition is disposed of by directing reconsideration of the entitlement of the petitioner by taking into account the stand of the department as would reflect from paragraph 10 of the affidavit in opposition.
To release the agreed amount,
Then
because my lord, otherwise the officers will miss it, again I have to come and.
No, no, that is an amount, that is, the calculation is
Agreed.
already there.
Already there.
I have already placed.
it is it's
Agreed amount.
clarified
To
that the
release
amount
agreed
which has been calculated
Yes.
Is to be released without any further delay, full stop. As regard at this stage, Ms. Saikia, the learned counsel, has prayed for a direction for payment of interest, full stop. However, comma, Sri Kolita, the learned standing counsel, has submitted that interest is not leviable, and in any case, the issue regarding entitlement for interest is presently pending in the Honorable Supreme Court. In SLP number, do you have the number? In the Supreme Court, full stop para. In view of the above, comma, the aspect of a claim for interest is left open, which would be subject to the views that may be taken by the Honorable Supreme Court.
Right. One thing, my lord, that in page 31 amounts are there, my lord. Don't know, my lord, that.
31 of the writ petition?
Page 31
Of
of
the
the
writ
writ
petition.
petition. What was the investment amount? What was the recommended amount? And my lord, page only 5 lakh.
Rather than
Out
that
of-
was lot of-
out of
In
17
the affidavit
lakh-
of opposition.
Yes, I have played.
Statement he has given in the
I
affidavit of
clarified.
opposition. Okay,
I hope so. Obliged.
okay.
But they will cut it.
I am appearing on behalf of 50 Sarma, standing counsel for FDC. If it is not well today, kindly.
Okay. 33. Madam, you are for Mr. Mahanta.
I'm appearing on behalf of P. Goswami,
Item number
33.
P. Goswami. Sanjeev Kumar Das. Mr. Mahanta's name is appearing. You are appearing on behalf of whom?
On behalf of petitioner.
Petitioner.
Yes.
On behalf of Mr. T.J. Mahanta.
P. Goswami, Miss P. Goswami.
P. Hazarika.
Yes, sir.
You don't know the name of your senior.
Actually, your lordship, I was engaged.
Okay. Doesn't matter. Okay. It is submitted that Sri P. Sharma, Learned Standing Counsel AFDC, is unwell. Full stop. List after a week.
Please, your lordship. My lord, this matter pertains to settlement of a work, my lord, for repairing and innovation of in-house diagnostic laboratories, my lord, in Lakhimpur district, my lord.
Yes, Mr.
Lordship, we have received the instructed, Lordship, request to short date, we will file a.
What about the Dusty respondent, private respondent is there?
Yes, your lordship, I have served one, my lord. Another has refused. Accordingly, I have filed affidavit.
Where is the office note dated 8/2/2024? No, I think it has been taken into consideration. 8/2. No, not required. Not required. 3 M. Bhuya, learned counsel appearing for the Health and Family Welfare Department. Sub- National Health Mission submits that instructions have been received and an affidavit would be filed within a period of 3 weeks from today.
Identify.
Please, Lordship.
What is this story?
Matter pertains to Lordship non-payment of the bills for supply of metals to the panchayat election.
Yes, yes,
My
Mr.
lord,
Dutta.
35, 36, 37, my lord, we need some more time. And as per my last instruction, our department moved for the finance department for additional budget.
Notice was issued on the last occasion.
Yes, my. My lord, and one more thing, my lord, finance department is not a party.
Okay, you get the instructions.
Yes.
You should have made a finance a party just to,
Yes.
for your own benefit. But nonetheless, you take the instructions. 3. As Datta Learned Standing Council, Panchayat and Rural Development Department submits that
For these cases, I don't have instruction, but similar cases are there.
submits that instructions are yet to be received. Full stop. He, however, informs this court that in some of the similar cases, comma, the proposal has been made to the finance department for release of funds. Full stop.
For
Para.
additional budget.
For additional budget. A proposal has been made to the finance department for additional budget. For para. List after 3 weeks to enable the department to file affidavit. Same order in all the cases?
35, 36, 37.
Yes.
All right.
Yes, we have taken the kept upon respondent number 5 by trustee Lordship on 22/2024. Lordship, may kindly peruse the order dated 26/7/2024 passed by this Lord.
It's deemed to be served, no problem. Yes, your
time to get the instruction of it. This is the peculiar case, my lord. Lordship comes to the last page of the last page, my lord, last but one, my lord. This is 195. All the tributors have same number. Yes, same amount have been put. And even after having the notice, it is not appeared. I have not received my instruction.
Respondent number 5 has no experience in the litigation.
how much is the bid?
1 crore 55 lakh 11,392. 0.00. And all the 3% is same number.
And I am at serial number 1.
Serial number 1, there is a condition.
Even 92 is there.
Yeah, every dot is equal. All the three.
Even the handwritings are the same.
No, this is a type copy, my lord.
Type copy, Lordship.
Same computer typing.
No, Lordship, if your Lordship comes to the.
There is some, and I have not received my instruction, my lord. Lordship will fix it after 2 weeks, my lord.
Lordship, what of the Lordship, if your Lordship comes to page 192, this is the impugn notice, to proceed with work. Because this is the public interest lies, Lordship. And he has, since 2023, Lordship, 25/9/2023, work order was issued to him. The private respondent.
How is it so such a coincidence that
Every dot is
Huh?
Because there is a condition, my lord. If all the all are equal, then there will be a different type of calculation.
No.
So that condition is there. So who is the highest in the
previous evening you sat together?
Page 46 is your of the NIT.
Not one evening, many evenings.
Page 46 of the NIT, Lordship. If your Lordship
You put this on record.
Lordship.
That may not be a good case.
No, I have
If
good
there is
case
an
because-
indication of a collusion and a forming of a cartel, then you'll be in difficulty.
And now, even after service of notice,
No.
it is not appeared.
Work order was not issued to me. Work order was issued to the private respondent number 5. And he is not executing the work.
So later on, there is a dispute between you and 5. There was earlier an agreement of division. Yes, that is what has happened.
But
You have not got your share.
But my learned friend is not able to take the inspection for last so
He's
many
working,
months.
he's going ahead with the work or what?
No,
R4.
nobody is
Nobody
working.
working.
They want to solve the process. That's the
No, we are not selling. The
What-
response number 5
Work
is
about?
1.55 crores. It is the
For-
irrigation project. 1.55 lakh and not amount. But
No, no, what is the work about?
it's the irrigation project of building of a canal.
Canal, okay.
Canal.
and he has no experience of it, that response number 5.
Something has gone sour between you and the SP number 5. Otherwise, you were friends. Okay. On the prayer of 3 as Bora, Leonard Standing Council, BTC, matter is adjourned by 4 weeks to enable filing of affidavit in opposition.
Which will continue to fix those things.
Yes, we fix a date, Mr. Bora? List on, date will be difficult. 1, 2, 3. It'll mean that will be 4 weeks. Otherwise, the week before the puja vacations, will not have time. We said 4 weeks. If it comes, it's okay.
Public.
39 I have not received my instruction is regarding obtaining bill, my lord. Okay, my lord, but we will fix after 2 weeks.
Okay. On the prayer of 3 as Bora, Leonard Standing Council, GMC. Further 3 weeks time is granted to enable him to obtain the instructions. 3 weeks, huh? Okay.
May I please, Lordship? Lordship may kindly see order dated 23 to 24, Lord. Contractual bill amount, Lordship.
Madam, instruction. Instruction.
We have communicated on 9/3/9.
3/9.
3/9. We have communicated to the department.
My lord. Same course of action, my lord.
Oh, yes.
Same course of action, my lord, second petition is filed. Earlier, my lord, we have filed affidavit in the matter, my lord. They're admitting the amount, and my purpose directed to make the payment as per
Samsarali.
Even without he submitting the copy to the authority, my lord, second petition has been
Yes,
filed.
yes, Lordship. We approached the authority, but authority did not take any step. They even did not receive our copy, Lordship. Lordship, we have annexed the order of the Honorable Court at page 56, Lordship, passed by earlier occasion, Lord.
Yeah, my lord, 12 of the petition.
56.
He made a statement that, my lord, he has submitted, my lord.
Yes, yes. No, no, Mr.
He made a statement in saying of 12, my lord.
12, yes.
That copy has been submitted, but no such data is there.
They say that the copy is not coming from the registry of the High Court, so you are not
Even, my lord,
accepting copy from.
Where have you
There
stated?
is no annexure.
Paragraph 12, Lordship.
Paragraph 12, my lord.
Paragraph 12. Thereafter, we approached the deputy commissioner also. They say that the instruction is to the engineer, chief engineer, so we cannot accept the copy. Deputy commissioner said so.
Why didn't you come for a contempt case?
Yes, my lord.
Lordship, the
How
actually,
can there be two adjudication of the same cause of action? Where are the principles of res judicata?
Actually, Lordship, after 1 year, the petitioner was trying to convince the authority by filing the copy of the writ petition, order of the
Where
court.
is the scope of second adjudication by the same court, same subject matter? Where will the principles of res judicata go?
Lordship, already 1 year elapsed in the meantime.
What did you do 1 year? Why didn't you come to the court for contempt?
That is why the this petition has been filed.
You cannot come up repeatedly with writ petition, same cause of action. What you say state may be correct. You have recourse in law, file a contempt in time, in the prescribed time.
So already filed affidavit, my lord. Yes.
And Lordship, contractual amount they have admitted the work was executed, Lordship. That is,
How do you adjudicate a matter twice? Same cause of action,
Lordship,
same parties.
as the 1 year elapsed from the passing of the order of.
This is not maintainable. This is not maintainable. What steps are you taking for release of the amount? Is he empaneled under the?
He is entitled, my lord. We have.
Is he empaneled under the Tamser Ali?
That I have no knowledge, my lord, regarding my lord, because he has not furnished a copy of this order to the authority, my lord. There is no acknowledgement that he has submitted a copy.
From where do you get it? From where are you submitting?
Paragraph, my lord, page 52, my lord. We have already, my lord.
You filed affidavit?
Yes, earlier we have filed a affidavit, my lord.
No, not this. You are saying that the order copy passed in the earlier proceedings have not been given to you. From where are you making this evidence?
My lord, appears from paragraph 12, my lord, of the page 12, my lord, of the.
Yes.
Paragraph 12, we did not say that we did not approach the authority.
I mean, in that case, my lord, here, punished, so, my lord, is the post, my lord. If authority is not, my lord, accepting, my lord, that should have been a acknowledgement, my lord.
My bill amount is lordship 16,53,000. And I am not sitting idle, lordship.
You cannot file a writ petition for execution of an earlier order. We are not an executing court. We close this. Heard Sri M.I. Hussain, learned counsel for the
Lordship, I may
petition.
be allowed to file appropriate petition, Lord.
Under which provision? It is barred. But we'll say something. Don't worry. Learned, for the petition. Also heard Sri M. Chetia, learned State Council. Also heard Miss S. Sharma, learned Standing Council, PWD. Sri S. Datta, learned Standing Council, Revenue. And Sri M. Chetia, learned State Council. Full stop. Para. The instant petition has been filed with the following prayer page. Prayer to court Korijiba. Page 13-14. Full stop. It, however, appears that with the same cause of action, the petitioner had earlier filed WPC 172 of 2022, in which this court had passed an order dated 22/6/2022. Full stop. Para. The learned counsel for the petitioner has, however, submitted that the copy of the order passed by this court was refused to be accepted in spite of several attempts, and therefore there is violation, intentional violation. Full stop. In this regard, he has referred the pleadings in paragraph 12 of the writ petition. Full stop. Para. The learned counsel for the respondents, however, has submitted that a second writ petition on the same cause of action is not maintainable. Full stop. He has also, it is also submitted that in the earlier writ petition, affidavit was filed wherein it was stated that affidavit filed by the Deputy Commissioner, wherein it was stated that in terms of the judgment of the Honorable Full Bench in the case of Tamser Ali versus State of Assam, the case of the petitioner will be dealt with. Full stop. However, from the pleadings, it has been submitted. It has been submitted that from the pleadings, it would appear that the copy of the order itself was not furnished. Full stop. It is also submitted that even if the averments made in paragraph 12 of the petition are assumed to be correct, the petitioner could have sent the copy of the order by registered post which has not been done. Full stop. Sri Chetia, the London State Council, has submitted that when all certified copies of the orders of this court are accepted, it is difficult to accept, it's difficult to believe that the copy pertaining to the petitioner would be refused to be accepted. Full stop, para. Though the the cause of action thought to be espoused was the exact cause of action which was espoused in the earlier writ petition as mentioned above. Full stop. The said writ petition was disposed of by this court wide order dated 22/6/2022. Full stop. It is not known as to why the petitioner did not approach this court by an appropriate petition alleging violation, if at all the order copy was not accepted and the directions not complied with within the time prescribed. Full stop. Approaching this court for the same cause of action is barred in law under the doctrine of res judicata. Full stop. In any case, so far as the relief sought is concerned, a writ court cannot be an executing court for an order passed earlier. Para. In view of the above, the writ petition is held to be not maintainable and accordingly dismissed. Full stop. It is, however, made clear that the earlier direction passed by this court for passed by this court after an affidavit by the department may be taken into consideration after in consideration for and steps be taken for enlisting the petitioner as per the direction of the Honorable Full Bench in Tamsir, provided the petitioner furnishes a copy of the earlier order to the respective authorities. You have not done, you do it. If he is not taken by hand, give it by registered post. Why should your copy not be taken when petitions, copies of everybody has been taken?
I'll supply copy. Time frame may be given for the.
What time frame? Give it immediately. They have stated on affidavit, they follow absolutely what they have they do not have any other option where they have to follow. Yes, next.
May it please your lordship, my lord, regarding item 39, my lord. My lord, I am appearing on behalf of Espitas.
Yes.
My lord, may kindly fix a date, any date after 3 weeks.
After?
3 weeks. My lord has given a time of 3 weeks.
After 3 weeks, we cannot fix a date. It will be just a week prior to the long vacation. We'll not be able to take up orders. If it comes within on its own, it's good. Otherwise, it'll go after the vacation. Okay, next.
Obliged.
Yes.
The matter regarding establishment of a new market. In this case, the local public filed an application before the local MLA. Then the matter was forwarded to the
Yes, yes, instructions. Instructions.
Yes, we have instruction, my lord. So we would like to file an affidavit. Otherwise, my lord, page 53 is clear that my lord, 2 market has been settled by the Jila, and this new market is unauthorized.
Not unauthorized. It is established by the Ancillary Panchayat. And we are not allowed to run the market since it is a new market.
You filed the affidavit on the prayer of Sri so London State Council, Bokolial, huh? Matter is adjourned by 3 weeks to enable filing of affidavit in opposition. Okay. What is the matter?
Matter for the
Health. Mr. Gogoi. Madam, Mr. Bhuya.
Supply dietary services to the Nalbari Medical College.
Supply of
Dietary services to the patient.
dietary.
Diet services to patients of the Nalbari Medical College. If challenged the cancellation of the e-tender process, we declare it L1 and the tender process has been cancelled without assigning any reason.
Yes, affidavit filed.
Yes,
The
my lord,
proceedings are otherwise complete.
there's some urgency on our part regarding supply of dietary
Is there a stay order?
No, well, presently it is the petitioner who is my lord supplying. Interim management. Because earlier civil hospital, my lord, the petitioner was supplying. Now it has been converted to.
There's no restriction from this court.
Yes,
You take your call. If you want to engage anybody, you engage.
No, we'll have to go for a fresh tender. And
Go for a fresh tender. Where is the restriction?
let it be on 11, my lord. Wednesday, 4th. Otherwise, my lord,
Madam?
reason is this, my lord. Earlier, right now, my lord, presently, the petitioner is supplying at the rate of 124 rupees per meal for the entire day, 4 meals to 1 patient. Now, in this tender process, he has quoted 78 people. Just one some. So the tender committee has my lord, quoted viable.
78, how can you supply food?
Yes.
For
Including
the
my lord,
whole day?
veg, non-veg and all, fruits and all.
78.
Too low.
But the affidavit we have stated that there's other medical college that has been supplying in 73.
70, what
The records will suffice.
quality would be there? 73 whole day, can you survive? What would be the quality of the food?
So we'll have to compromise the quality.
But may fix it on.
You can supply within 25 rupees also. Or 10 rupees, or don't give them anything, give them water. That will diet for a patient. You cannot compromise. We are not saying that you have to have an extravagant or something, but minimal 78 is too less. It would be unviable. Unviable. And who are the others?
Others will say 70, but why no differences? So, my lord, we have Court issue on Monday or Wednesday?
Okay. Wednesday.
Wednesday.
On a prayer made on behalf of Sri D. Das, London Senior Counsel for the petitioner. List on Wednesday.
The vehicular seat in March 2019, my lord, was loaded with limestone. Then we approached the director of geology mining that this limestone.
Item number?
Item number 60, my lord. Page 48, you'll also find, my lord, that the procedure list on 13/3/19, my vehicle loaded with limestone was seized by post. Then I approached the director of geology mining, who, my lord, directed them to send a sample for analysis.
Yes, you said there's a coordinate bench judgment.
My lord, in fact, that matter is still pending. My lord, this is the same petitioner, my lord. Now he has changed his name. He has changed his name. This is Ashish Tusniwal, my lord. Earlier he used to run SLT Infracon. Now he runs GD Industries. My lord, PIL, my lord, I've given the copy of the PIL also. In this, my lord, the issue crept up that whether limestone is a forest producer or not. An interim order was refused. The other single judge, my lord, held, my lord, in the view of certain judgments, my lord, that limestone is a forest product. It might not be a mineral, but it's a forest produce. So interim was refused. Against that interim, my lord, the petitioner, my lord, went to the division bench. Division bench interfered to the extent that their licenses are limited, a license are periodic. So that finding was interfered that this is a minor mineral, or it is a forest produce. So we have the competency to control it, my lord. In this case of the petitioner, my lord, the license, the stone cluster was established by the forest department. The regulations are of the forest department, the environment forest department, but the petitioner started to crush limestone in that cluster, my lord. That was the offense. And as for the vehicle, my lord, the vehicle, we had filed an FIR, my lord, the vehicle is with the police. No, that is still lying with them, my lord. We have filed the which annex the photographs also, that is still lying with them. Your lordship may just see PIL, my lord. that is covered by.
Now, where is the affidavit? So that so far as the
Affidavit reply, my lord, 28/11/20.
the vehicle is lying with the forest department.
First given.
Yes, Mr. Google.
And moreover, my lord, PIL, your losses may just see the PIL copy I have given, my lord. It is just covered by PIL. Because limestone, they don't have the authority, my lord.
No, that question we may not enter just now. We are mainly worried with the vehicle, concerned with
My
the
lord.
vehicle.
So in my affidavit, my lord, I have annexed an FIR, my lord. It's page number page 26, my lord,
Of
the affidavit in opposition. My lord. They have whether case has been declared or not. And that apart, my lord, these photographs annexed by my senior counsel, my lord. These photographs are undated, unauthenticated, my lord. Who knows what the time frame is not indicated, my lord. When it was the post FIR of the FIR.
26, 100 FIR. Where is your averment, Mr. Sayola?
My lord, regarding
Regarding the vehicle in
there are
custody
12 my lord, of the affidavit.
of the reply affidavit.
Reply.
Page?
Page, my lord. Oh, page 9. Oh, no, page not page in it, my lord. It's paragraph 12. Oh, okay. 29. The last three sentence, my lord. Five sentences. The phone of first authority of legal state of vehicle of the petition would not be handled over claims of police authorities as the claim by the son of five. The knowledge of the petitioner, the vehicle is still lying in the custody of forest resource center. The vehicle lying in the campus of the copy of the photographs and about the vehicle is lying in the photocopy we have annexed.
Why don't you take
Well, I
specific
want to
instruction
take,
from
yes,
the beat
fresh
forest
instructions, my lord. My lord can list this on next week. I'll have fresh instructions.
on this
Vehicle issue, my lord. Vehicle and more, my lord, the entire matter is covered by this PIL, my lord. If your lord will see. No, it is covered. That PIL, my lord, is your lord is must see, my lord.
Who has started drafting your affidavit, Mr. Sayola? I think it's not been vetted by you. You come to page paragraph 9.
9. Yes, all. Long paragraph.
How many pages?
Paragraph 9 is very long.
4 pages.
4 pages.
Not to be done like this.
Not
You must have might not have seen it. Follow the earlier practice.
Yes,
Young
yes.
counsels.
Please tell him.
Take help of your seniors, not like
Sure.
this. It's inconvenient.
Hello?
Other than other things, it's very inconvenient.
Yes.
You cannot point out which part. Okay, Friday next.
Right.
Okay. Please, Sayola, the learned senior counsel for the petitioner. Apart from other submissions, has contended that the vehicle in question is lying with the forest department. Full stop. He has drawn the attention of this court to the averments made in paragraph 12 of the affidavit in reply filed on 28/11/2022, wherein it has been specifically stated that the vehicle is in the custody of the beat forest officer, Sealtech, Sealtek. Sealtech, where is Sealtech? In the district of Hailakandi.
Karimganj.
Karimganj. What's the para? Let instructions be obtained in this regard by Sri D. Gogoi. the learned standing counsel forest department.
And moreover, my lord, if the lawsuit sees a PIL,
We'll consider. At least vehicle part, we want to pass some sign orders. List on Friday next. We'll have it on 13.
13, my lord. 13. Hold it.
If I could peruse that medical report, it says that I was found to have moderate intellectual disability. Lordship, otherwise on perusal of the entire report, I cannot see whether this moderate intellectual disability renders me unfit to have a license to run a fair price shop. Lordship, otherwise my argument is that intellectual disability as a blanket cause, can it ipso facto disentitle me from holding a license to run a fair
These are
price
within
shop?
the prerogative of the, it's not a private business. It is
Lordship,
under certain regulations. You are under somebody.
Lordship, I understand, but I was
And if
granted
they
the
are
license.
private business, somebody is making a restriction, then you can say it's a run at my own risk. Now they have come to a conclusion, that too after an order of this court. It's difficult, and you can challenge that. We can give you liberty to put that into challenge.
Lordship, I had already challenged this by way of this petition itself, that otherwise.
But after the orders of this court, wherein a board has again examined
Lordship, that
you.
was one ground. Out of the several grounds that I took, one ground was that the constitution was in itself not legally
So
sustainable.
that is why on 29/7, the court ensured that since you had a ground that the board was not properly constituted, let a board be constituted, fresh board, it's constituted, examined.
Lordship, if Lordship may grant me some time, I am relying on one judgment by the Honorable Supreme Court.
Citation?
Lordship, citation is 2018, volume 11, SCC 197.
2018.
2018, Lordship.
11 SCC.
Lordship, I believe a copy of the report is, I'm not sure whether the report is there before your Lordship or not.
11 SCC.
Yes, 11 SCC 197.
197. Yes, a name?
Judgment is Rima Taipoda versus Arunachal Pradesh Public Service Commission.
Yes, Rima Taipodia.
Yes. Lordship, kindly peruse paragraph 3. May I read paragraph 3, Lordship? I believe the medical report is there before your Lordship.
Paragraph 3.
Paragraph 3. The requirement was minimum 40% disability. That disability is to be verified under the Persons with Disabilities Rules 1996. Rules 4 and 5 read as follows. 4. Authorities to give disability certificate. Lordship, yes, I'll continue reading. A disability certificate shall be issued by the medical board duly constituted by the central and state government. 2. The state government may constitute a medical board consisting of at least 3 members. This aspect I brought before court slide that they seem to have rectified by getting it done by 3 members. 3rd, the medical board shall after due examination give a permanent disability certificate in cases of such permanent disabilities where there are no chances of variation in the degree of disability. This again, they have not complied with. Subsequent paragraph, Lordship, there's another aspect. The medical board shall indicate the period of validity in the certificate in cases where there is any chance of variation in the degree of disability. My disability might be temporary also, Lordship. My disability may be permanent, temporary. There are various aspects. These aspects need to be otherwise discussed, and then a proper comprehensive report has to be given. No refusal of disability certificate shall be made unless an opportunity is given to the applicant of being heard. Lordship, these are the criteria that have been laid down by the Honorable Apex Court. Lordship may also take note of the new act Rights of Persons with Disabilities Act 2016.
Yes, for the purpose of?
Lordship, since intellectual disability otherwise is only covered in Rights of Persons with Disabilities Act.
Yes.
Lordship, can kindly see section 2S.
Definition.
Section 2 clause S. Yes, definition.
Yes.
First, person with disability. In the schedule, the term intellectual disability has been defined, Lordship. And therein, there are several categories of intellectual disability. Even a person with mild autism is considered to be intellectually disabled. Now, Lordship, otherwise, a mild autistic person, he can drive a car also. So, to come to a conclusion that a person with intellectual disability can be striped off from having the license, Lordship, that I'm challenging.
What is your name?
Lordship, Y. Kothari.
Mr. Kothari, this report, have you been furnished with this report?
Lordship, that day I had asked for a report. So
No,
Lordship had
you
directed.
can make this submission if you make a proper challenge to the outcome of this report.
Lordship.
Then we'll be in a better position either to address the court and we can answer your. In this
Lordship.
petition, it will be difficult. You can take up any other issues.
Lordship.
But without a specific challenge to this report, it will not be proper. Though it is directly connected.
Lordship, then if I may, Lordship, just last, if Lordship may hear me. So even previously, the report was not furnished to me. Lordship, may kindly see.
No, it is only recent, 19/8/2024, it has been forwarded.
Yes. Recently, Lordship.
Recently. So you will be given a copy of this report. When was this examination done?
Lordship, Nogam.
No, when?
1908, Lord.
19/8. 19/8 is not a long time. 19/8 is the forwarding. Examination was done when? We are not very sure.
8/37/2024 is the
See, the
reference.
conclusion arrived at by the board. You may have grounds to assail this. You put this on, we'll ask madam to give you a copy.
Lordship,
Already given.
Lordship, lastly, order dated 15/7/2024.
15/7/2024. Of this court?
This court, Lordship.
Yes.
So, Lordship, what has happened is I was granted the license. I was running the fair price shop. My father was also a license holder. Then it was suddenly cancelled. So, on the basis of certain allegations,
Yes.
even the copy of allegations has not been provided to me. So, this honorable court had specifically directed that the copy of allegations at least has to be brought on before the court on record. So, this has not also been complied as of yet, Lord.
What allegations? What?
I am not aware, Lord. I was
No,
running.
not in the, we know you're not aware. What was the, what is the prelude to the, what there's some allegations were made
Lordship,
against
if
you?
I'll direct your Lordship's attention directly to the particular order. Page 39.
Of the writ petition?
Yes, 39 of the writ petition.
39, yes.
So this is 20 to 25 days after I was granted the license and I was running.
The mental health report is.
Annexure G.
Please read.
So this is it, Lord.
Please read.
Lord, okay. Lordship, in reference to the subject cited above, it is to inform you that a mental health report is required of the person, namely Sri Dayananda Bora, who happens to be the petitioner, as there are allegations against the mental health of Dayananda Bora. Hence, you are requested to conduct a medical diagnosis and submit a report about the mental fitness of Dayananda Bora to run a fair price shop, Lordship, to run a fair price shop, where essential items like rice, etc. is provided to
Yes.
ration card holders. After this, what happened? I was not given that copy of the diagnosis. I was not even aware. Then an affidavit in opposition was filed by the respondent number 4.
Yes.
Yes.
Your lordship kindly perused that medical diagnosis I had said. Lordship may kindly see page number 49. That is the affidavit in opposition filed by the respondent number 4.
Yes, got it.
Now I came to know. So Lordship, see, subject, a report on mental fitness of Sri Dayananda Bora. And
Yes.
it says, in reference to the subject cited above, it is informed that Sri Dayananda Bora, so and so,
Page
attended a
47,
49, Lordship.
49.
But if this casual letter is a medical report, this I had first brought before court slide, I challenged, then court had directed that a proper report may be funded.
Yes.
In reference to the subject cited above, it is to inform you that Sri Dayananda Bora, age so and so, attended the medical board at PP Civil Hospital. On evaluation, Sri Dayananda Bora is found to have intellectual disability, due to which he is mentally unfit to run a FEPRI shop. That's it. So, no diagnosis. Now, Rights of Persons with Disabilities Act 2016. Otherwise, that is also not proper as per. So, Lordship, here there are two doctors. This I had challenged. Out of several submissions made by me, I have challenged that only 2 doctors have done it. This is not in compliance with the mandate of the Honorable Supreme Court.
Yes.
So that aspect that was rectified. But despite that, Lordship, no percentage, no threshold. There has to be a certain percentage that below this percentage, I will be rendered unfit to run a FEPRI shop. These aspects, Lordship, otherwise have to be complied with. Particularly, section 56 and 57 of RPWT Act now mandates it.
So this needs to be put on record. You find if you seem to be aggrieved,
Lordship.
you put a formal challenge to this.
Lordship.
Heard Sri Y. Kothari, learned counsel for the petitioner. Also heard Ms. S. Sharma.
For respondent.
And then also heard, no, not 7. For M. Chetia, learned State Council. Cooperative Societies, why? Miss, your name? Put your name, okay? For respond number, for on behalf of the Standing Council Cooperative Societies, as well as Miss S. Sharma, then Standing Council Health Department, for the respondent number 9. Full stop. Para. The grievance raised in this petition was with regard to an order dated 8/2/2023, whereby an earlier order of 19/10/2022 of grant of a fair price license has been cancelled. Full stop. The said order, said impugned order emanates from a medical certificate dated 5/12/2022 on the mental fitness of the petitioner. Full stop. Para. As per the facts projected in the petition, please have your seat. The father of the petitioner had a fair price shop in the district of Nagaon, and after his demise on 21/11/2021, the petitioner applied for the license, which was supported by a certificate of mental fitness. Full stop. The license was accordingly issued to the petitioner on 19/10/2022. Full stop. However, on 9/11/2022, a letter was issued by the Office of the Deputy Commissioner, Nagaon, to the respondent number 9 hospital to refurnish a medical report of the petitioner. Full stop. it is submitted by the learned counsel that such a step was taken apparently on certain allegations which were never furnished to the petitioner. Full stop. Nonetheless, comma, on 5/12/2022, a summary report was submitted that the petitioner had intellectual disability, and based on the same, the cancellation order dated 8/2/2023 has been passed. Full stop. Para Sri Kothari, the learned counsel for the petitioner, has submitted that before redoing the medical examination on the aspect of mental fitness, comma, the allegations ought to have been made known to the petitioner and an opportunity be granted. Full stop. So far as the certificate dated 5/12/2022 is concerned, comma, it was projected, no, it was averred, it has been averred in the writ petition that the same could not have been construed to be a report in the true legal sense. Full stop. It is submitted that apart from the certificate being issued by only 2 numbers of doctors, comma, the parameters which are to be taken into consideration were not there, and the certificate appears to be in a summary manner, which would be in violation of the law holding the field. Full stop. Sri Para. The learned counsel has, however, submitted that in terms of an order dated 22/9/2024 of this court, a fresh medical examination of the petitioner has been done, the outcome of which was not officially made known to the petitioner. Full stop. Para. Ms. S. Sharma, the learned counsel for the respondent number 9 hospital, has submitted that in terms of the direction contained in the order dated 29/7/2024, a fresh medical board was constituted in accordance with law, and the petitioner was examined. Full stop. As per the said report, as per the said board had come to a conclusion that the petitioner is intellectually
Moderately.
is intellectual, no, what is this? Is intellectually disabled of moderate level.
Yes.
Full stop. A copy of the report has been placed before this court and is also furnished to the learned counsel for the petitioner. Para. The earlier impugned order was impugned order of cancellation was based on a report dated 5/12/2022, which apparently do not meet the requirement of law. So, the present report present report states that the intellectual disability is of moderate level. Full stop. Whether the said disability of moderate level would be a ground for cancellation of the cancellation of the license is required to be reconsidered by the department. Full stop. This court is of the opinion that without making any observation on the authenticity, on the legality or otherwise of the fresh report which has been forwarded on 19/8/2024, interest of justice would be served if the writ petition is disposed of by directing a fresh consideration in view of the report indicated above. Full stop. The deputy commissioner, the nowadays district commissioner, I think.
Yeah.
District Commissioner Nagaon is accordingly directed to make a fresh consideration of the aspect of the continuance of the license, fair price license of the petitioner in view of the fresh report. Full stop. It is, however, this court further observes that in case a decision is taken against the petitioner, he would not be precluded from challenging the same in accordance with law. Okay. You reconsider. Moderate, it has been stated. Moderate can still run a shop. We have not said anything about the act because we don't want to close your doors tomorrow. If it's in your favor, nothing to be hesitated. Okay.
DP of like.
Okay. Mr. Nandi, what is this?
My lord, the root was issued, it is relating to the PTCL that the other Aditya rice mill, that amount was put us to the fee. And accordingly, on
What is this?
Your lordship, so we have to reconstruct our file as our file has been misplaced. So and to
APDCL?
yes, sir.
Okay, you will grant some time. 1
Yes,
week's
sir,
time.
and we will positively file the affidavit on the next.
Heard Sri D. Nandi, learned counsel for the petitioner. Full stop. Your name?
C. Paul.
SC.
C. Paul.
C. Paul. Sri C. Paul, learned counsel.
On behalf of KP
representing the APDCL, has however submitted that the papers have been misplaced and efforts are on to reconstruct the file. Full stop. Let the file be reconstructed, for which 2 weeks' time is granted.
Your lordship,
16 matter, 2 weeks' time is granted. Full stop. Para, interim order passed earlier to continue till the next date of listing.
much.
Yes.
I pray the Lordship. Appearing on behalf of each of my lordship, matter service has been completed. Respect lesson number 4 and 5. Matter be fixed to the
What is your name?
S.
S. Som.
S.
Write it down. I have not been able to follow. Submits, appearing on instruction of Ms. E. Shom, learned counsel for the petitioner, has drawn the attention of this court to the office note dated 22/7/2024. Full stop. On perusal of the same, service upon the respond numbers 4 and 5 is accepted to be complete. Para, list for admission in the next week.
This issue, my lord, we have instructions for the petitioner to withdraw, man.
Three, D. Gogoi, learned counsel, appearing for the petitioner, submits that there is instructions not to press this writ petition. Full stop para. Writ petition accordingly stands closed on withdrawal, as not pressed.
I prefer a couple of days to file my affidavit, my lord.
Here for whom?
One for respondent number 1 and 2 both. Is a contempt.
PWD. It's a contempt matter.
Contempt matter.
Okay.
We have received the
Sri
instruction.
D. Kolita,
Right.
learned counsel for the respondent numbers 1 and 2. Prays for and is granted 3 weeks time to file affidavit in opposition. Okay.
Obliged.
Use some personal difficulties, Mr. Armagundris. For your lordship, I pray for time
Okay.
for 2 weeks.
On behalf of Sri R. Mazumdar, learned counsel for the applicant, our prayer for adjournment has been made. Full stop. List after 2 weeks.
Okay.
Yes, 51.
Please review petition 30. Earlier occasion lordship.
Yes, review.
Review. Earlier occasion education department was
Notice the
Oh, your case was not.
lordship.
yes.
Something was left out, the
Yes.
discussion part.
Yes, yes.
Part 3D Mohamta. ये फर्स्ट पैराग्राफ ऐसा ही होगा 14.8 का 14.8 2020 फर्स्ट पैराग्राफ हाँ What was the ground exactly?
I think lordship, my mark and my case was not considered. There are also 13 cases.
It is submitted that while 13 numbers of cases, writ petitions were disposed of by the common judgment and order dated 9/3/2022, there was no discussion of the case of the petitioner, which was WPC 5578 of 2020. Para. Let notice be issued. Returnable by 4 weeks. Sri D. Upamanyu, learned counsel, learned standing council health,
No, Lord, higher education.
standing council higher education department accepts notice on behalf of all the respondents.
No, Lord, 1 and 2.
Respondent number 1 and 2. Extra copies within 2 days. Steps for service of notice upon respondent numbers 4, 2, 3, 4, and 5 by registered post PTAD. Okay. We will discuss the matter.